be taken up at 2 lot. Item number 3, I have to place lordship judgment in the NDPS case lordship. It is a intermediate quantity lordship. Nothing has recovered from this petition at 2 lot. Highly up.
One AP dot that take up at
Similar to PM, and yesterday I had filed. The number kita look.
also document item number
Item number.
21 and 22. City is not available.
Item number
21, 22.
21, 22. नाम kita di bawah नाम kita.
Very well clear.
Yes, take that.
22
Operate for another date.
दूसरा है क्या नहीं? मतलब
Which date?
मतलब 22nd of January.
Hello.
Back to mention item number 19. In this matter, Mr. R. Kolita is appearing, and not like to take up the matter.
Item number
19. On
Is also not available, मतलब?
interim may be accepted. Hello.
I get to mention item number 23, but it is not here. Petitioner is on interim measure. Only after 2 weeks. Yeah, Mr.
22nd January.
Let this case be
Interim order. Apply. Maybe. Hello, I beg to mention item number 28 match. It is not fixed match. Not fixed date after vacation matter.
Interim?
Interim, no interim.
मतलब 8th of January.
8. What is your name?
KU Ahmed.
I see whether in this type of case, whether my custodial interrogation is required or not. I will come to the FIM page 12, my lord. If an informant tried to keep the color of a criminal case, page 12, my lord. But allegation the FIR is that my lord, the informant and the my lord accused entered into an agreement for sale, my lord, and I have not honored, my lord. When after receiving some amount of money, against me, my lord, the allegation is page 13, my lord, in third paragraph. Second and third. The main allegation is at my page 14, my lord.
What is the
But it says, my lord, the not the accused, my lord, accused prisoner and the my lord, the informant, my lord, that into agreement for sale, my lord, for purchasing one plot of land, my lord. And to that effect, my lord, the informant has paid 1/3 of the amount, and he did not honor it, but as yet, my lord. So, my lord, instead of my lord filing a suit under the relief act, my lord, the informant my lord, lost this FIR, my lord. Instead, my lord, because he has not honored, my lord. And the petitioner is behind the bar, my lord, from 6/12.
yes, Mr.
अगर in this case petitioner was shown arrested on 6/12 में.
He's not thrown arrested, my. He was arrested on 6/12, my.
Shown arrested?
No, no.
तो तुम्हें लिखी से.
No. He surrendered on 5/12, my lord, and he was shown to be arrested, my lord, on 6/12, my lord. We raised this issue, my lord, in the lower court also, my lord, on the day of production, my lord.
Then why the court below
Now, my lord, the court below, my lord, see, my lord,
rejected the order?
court below order is that, my lord, page 34, my lord. only the court below my lord after the IO my lord to bring the my lord the DTNT my lord. Then my lord taken my lord after the DTNT my lord later part of time also my lord. The perusal of the city further revealed the accused person has been arrested and so and so the accused person appeared before the concerned PS. He himself gone there my lord to the PS my lord. It is not that my lord I am evading the arrest or investigation.
Any thought that may be fixed.
Okay.
Because only three my lord whether these kind of cases whether capturing the is required or not.
No, the, well, which court has,
Well, I is my lord.
Supreme Court has rejected your prayer after that.
Yes, I know.
We are fixing on third. Third,
As court of my lord.
as court of the court of the fact that therefore dictated by the which had been after the case and would be decided for considering that the third separate
All right.
Is charged metal of commercial quantity scan copy of
third is the case for Supreme Court. Let the scan copy of case record of NDPS case number 201/23 along with case diary of STFPS case number 4/2023 be called for from the court of session that approved the registry to take step for the let this matter step 23rd.
no letter may be even due and vacation will be there. After first week of February,
Let this matter be listed in the first week of February.
because scan copy have to come. Much obliged. Much obliged.
Happy to know. Hello, FIR is page number 11. Matter relates to a small quantity of heroin, my lord, recovered from my possession, my lord. The accused, the petitioner before lordship is Nihal Hendrik, my lord.
Since when you are
Accused.
detained?
Accused 3, my lord. Accused number 3, my lord.
Small quantity,
Small one, 3 grams, my lord, of heroin, my lord.
only 3 grams.
Only 3 grams, my lord. All right, my lord.
3
Self-
grams which contain
Okay.
Third,
That-
Mr.
Yes, I can.
A. Soikel, and it counsel for the board of the petition this application report 39 of the court of 1973 by the petitioner who has been detained behind the bar since 3/12/2020 in connection with Bhutia PS case number
Okay,
135 /2023 under section 21A/29 DPS Act, 1985. The allegation against the present petitioner is that was found possessing what is
3
the 3 grams of
3
heroin. So, considering the fact that quantity of contraband is from the present petitioner is of small quantity is of small quantity, comma, the petitioner, the above named petitioner is allowed to go on bail of 30,000 with one security of right amount. To the satisfaction of learned special judge,
Special judge,
where
special judge, Vishwanath Third.
special judge Vishwanath Karan with with following condition. One, number three, he shall not indulge in similar offense while on bail with above of the bail application.
I'm deeply aware, ma'am. I'm deeply aware.
May I please, Your Lordship? Lordship, the petitioner before you is a person who is engaged in the activity of fishing. Lordship,
Is this a civil bench 5 matter?
Lordship, because of this FIR, Lordship, I have to file this petition criminal, Lordship. Because of this FIR at Annexure B,
But this
Lordship.
court can look into only the aspect of watching regarding your fishery right,
Lordship.
not the proper.
But under 226, Lordship, for the.
But this court is not taking up for fishery right. You have to file a separate. You cannot club together.
Lordship.
You have prayed interim relief only regarding fishery right.
Lordship.
So we can issue notice as regards your prayer for quashing of affair.
Lordship.
But
But
other
Lordship,
relief,
in my humble submission, Lordship, under 226, I think Lordship has the.
but I am not taking up that way. There is a separate roster for
In that case, Lordship, I have to file a separate writ petition
yes,
for
perhaps yes.
civil writ petition.
Civil remedy you cannot take from the
Lordship will issue a notice today so that.
heard Mr. P.P. Medhi and its counsel for also heard that he brought up to the petition for this application of the section 226 slash 48 226 of the Constitution of India read with section 482 of the Code of Criminal Procedure, 1976 has been filed by the petitioner Prashanto Rajpur, praying for quashing the criminal proceedings initiated on registration of the FIR dated 28/8/2020. Issue notice to the respondent and which case has been registered.
Lordship, this is Nipuria PS case number.
In this case, PP Assam is not a party.
Yes. You have not made public prosecutor, but there are defects. This matter should go to civil bench, right? But you have not made
PP.
public prosecutor. State of Assam, you can represent number 1 and 2.
Yes, well, the copy is also not served.
I'll
Right.
yeah, respondent. The since learned additional public prosecutor has appeared for respondent number 1 and 2, no formal notice need to be issued. However, the petitioner shall furnish requisite copy of the writ petition to the learned additional public prosecutor during the course of the day. As regards respondent number 3 is concerned, the petitioner shall take steps for issuance of notice on respondent number 3 by registered post within 3 days from the date of this order, returnable after 3 weeks. Let this matter be referred.
Oblige, Lordship.
Well, in this case, I will confirm from the IO regarding the service of notice. Probably postpone
Okay.
is Can this matter will fix on 10-1 in the meantime? Notice not yet.
Notice has not yet served.
So,
Heard, Miss. What is your name? R.R. Bora. R.R. Bora. What is your name? Heard Mr. A.A.R. Karim, Planet Council for the petition. Also heard Mr. P. Bodhakur, Planet Additional Public Prosecutor. It appears from the record that the notice issued to the respondent number 2 has not yet been served. Learned Public Prosecutor is Learned Additional Public Prosecutor is requested to ensure service of notice to the respondent number 2 and furnish a report received in this regard from the officer in charge of jurisdictional police station before me. Let this matter be
on
decided
10-1.
10.
Ma'am, 438 application, my lord. FIR is at page 12, my lord. The petitioner is a contractor, my lord. One of the NIPA, my lord, has filed his FIR, my lord. Alleged that, my lord, his daughter-in-law was harassed by the petitioner, my lord. Page 12, my lord.
What is the allegation?
My lord, allegation is that, my the accused petitioner, my lord, forced the, my lord, the daughter-in-law of the informant, my lord, to do some, my lord, bad things, my lord. And in one evening, my lord, married, my lord, since last 2-3 years. Yeah, but Hip line, my lord, since last 2 years, and Assamese family staying near was constructing house. On 15/11/2023 at around 2 p.m. one took the visit of their house by taking the advantage of no one being at home. Pushed my daughter-in-law to go to Bhasan. Thereafter, again in the evening, while my daughter-in-law went to stop the Hakan so thereby holding her there. When after all this, today, at
Yes,
when
Mr. Bodhakur.
the victim, my lord, he has not filed his FIR, my lord. See, my lord, her in-laws has filed his FIR.
No, but anybody may file a file.
Yes,
The question is the offense.
Otherwise, my lord, the allegation is also that he is also threatening that if we approach the police, no,
and my explanation is at page 4, para 4, my lord. But the husband of the, my lord, the victim, the daily was broker, my lord. He works under the, my lord, the accused petitioner. He borrowed some money, my lord. And when he asked for, my lord, money, my lord, to return the amount, my lord, this allegation has come. In page 4, para 4, my lord, I explained, my lord, what is actually happened.
What is your submission?
my lord, at this stage, CD may be called for on 4th or 5th of January.
In the meantime, my lord, because my lord, clearly see page 4, my lord, because the husband of the, my lord, victim has borrowed some money, my lord. Then I have to return the amount, my lord. This FIR has been filed, my lord.
No, that is your plea.
Yes, my lord.
4th of January, my lord, I can produce the case.
The allegation is hugging and kissing,
Yes,
Yes.
not beyond that.
yes, my lord.
Let him appear.
Yeah.
Mr. S. Bodhakur, Learned Counsel for the petitioner, also heard Mr. P. Bodhakur, the petition for this application under section 438 of the Code of Criminal Procedure number 1973 has been filed by the petitioner Debajit Gogoi, alias Huntu Puan, who is apprehending his arrest in connection with the NDPS case number
Mhm.
239/23 under section 341/353/4/448/506 of the gist of accusation against the present petitioner is that on 19/11/2023, one Sanju Das had lodged an FIR. No, no, the name Nam Nitito. The victim has lodged the FIR that no, one Sanju Das has lodged the FIR, comma, inter alia alleging that the petitioner on that on 15/11/2023, comma, the petitioner taking the advantage of absence of other family members in the house entered into the house of uh, was the daughter-in-law of the go to Patan means
It's a Kalikuta Bhasan matter. They perform Kalikuta. There must be some relation between them, otherwise, how?
when detail. It is alleged that the it is alleged in the affair that the present petitioner had hugged and kissed the daughter-in-law of the informant. And also her threatened the present threatened the informant not to approach the police and not to lodge any FIR. So, learned counsel for the petitioner has submitted that the petitioner had that the who borrowed money,
But the husband of the victim, my lord.
the husband of the victim had borrowed some money from the present petitioner and had not yet returned the same back, not yet returned it back, repaid it back in spite of repeated demands from the present petitioner and the present and failing to repay the money. The present FIR has been the FIR has been lodged against the present petitioner only to harass. It is further submitted by the counsel for the petitioner that petitioner is ready to incorporate in the investigation. On the other hand, the petitioner for prosecutor has submitted that perusal of case diary
On-
for the
25-1.
1625. However, considering the allegation in the level in the FIR, as well as considering the nature of allegation level in the FIR, as well as submissions made by the counsel for the petitioner, namely Deputy Gogoi alias Huntu, is hereby directed to appear before the investigating officer of Dekoi PS case number 239/2023 within a period of 10 days from the date of cooperate of if he does within stipulated period of time in the event of arrest in connection with the PS case 39/2023, he shall be allowed to go on the bail of 30,000 with one security like subject to the satisfaction It's okay. Let this case be taken again on
5-1.
25.
Section 4 postpone.
Your lordship, in respect of item number 9 as well, it is same FIR. Your lordship, maybe please take up item number 9. Item.
Section 4 postpone.
Your lordship, at item number 9, the applications are under section 121 and 506. Your lordship. And the FIR has been launched after a period of 40 days, exactly after 40 days. And the allegations are against his own father. There are 6 accused, your lordship. Accused number 1.
Section 4 is
Section 4 is there, your lordship, but in respect of section 4, in respect of accused number 1. May I read the FIR, your lordship?
Yes.
Page number 7. সম্মানপূর্বক বিনীত নিবেদন এই যে যোৱা ইংৰাজী 25/8/2023 তাৰিখে বিয়লি 4টামান বজাত উক্ত 1 নম্বৰ আসামীজনে তেওঁৰ ঘৰ সাৰিবলৈ মোৰ নাবালিকা কন্যা মৰ্জিয়া খাতুন 17 বছৰক মাতে আৰু সেই সময়ত মৰ্জিয়া খাতুনে গৈ তেওঁৰ ঘৰ সাৰি থকা অৱস্থাত হাত ধৰি চুচুৰাই নি তাইৰ মুখত কাপোৰেৰে সোপা মাৰি ধৰি কাপোৰ কানি খুলি 1 নম্বৰ আসামীয়ে তাইক বলপূৰ্বকভাৱে ধৰ্ষণ কৰে। তাই চিঞৰ বাখৰ কৰাত আসামীজনে এৰি দিয়াৰ পিছত তাই ঘৰত গৈ মোৰ পত্নীক সকলো কথা জনোৱাই পাছত আমি গৈ
your name.
And Koli.
Item number 5. Mr. N. Tolita, the government advocate, appears for 1.
May I
This is item number.
This is more like a martyr petition, my lord. After committal, my lord, after case to the court of session, my lord, I should not appear, my lord. From 2019, I'll face the trial, my lord. I need only that observation. Against him, the enterprise as well as my proclamation has been issued. And my lord, shall we see
What is the offense?
489B and 120B, my lord. I will know you connected, my lord. Page 15 is a FIR, my lord. From 2 parts, my lord, the fake currency note has been seized, my lord, and my vehicle was used, my lord. And I approached this court, my lord, for granting of my lord bail, and my lord, see, my lord,
Prayer
Bail.
was rejected.
no, my lord, it was allowed, my lord, page 20, my lord.
Now, what relief you are seeking?
Now, my lord, the passage has been filed, my lord, and case has been committed to the court of session, my lord. It is now pending in the court of ethical session number 1, my lord. Approved, my lord. Now, after committal, my lord, I could not appear, my lord. And as a result, my lord, FPW and proclamation has been issued, my lord. And my lord, I am suffering from some dental issue, my lord. And now I am working as a worker in apart young Arunachal Pradesh, my lord. This is my 40,000 feet, my lord, from the sea level, my lord. So I will face the trial, my lord. And next date is fixed, my lord, on 4th of January, my lord.
No, you were shown as an absconder.
Yes, my lord. Well, I will face the trial, my lord. I need only that observation that I will face the trial, my lord. Otherwise, my lord.
Thereafter, you have not received
Yes, my lord.
Since 8/5/2019,
Yes,
he has not
I
appeared.
I admit, my lord, that I could not appear, my lord.
You want the NBWA to be kept in abeyance.
Yes, my lord. That's not only, my lord.
Heard Mr. H. Bhattakutan, counsel for also heard Mr. P. Bhattakutan, done an additional public work. This criminal petition has been registered on filing of an application of 482 of the Code of Criminal Procedure, 1978, praying for interfering with the order dated 29/11/2023 and earlier order passed by then the Court of London additional
Session Judge number 1, my lord, Kamrup
Section
Metro.
Judge number 1, Kamrup Metro. In session case number 21/2019 under section 489B/120B, whereby the non-bailable warrant of arrest were issued against present petitioner and the order for proclamation and attachment of property of learned counsel for the petitioner has submitted that though the petitioner is no way involved in offense alleged in, however, the charge sheet has been laid against the present petitioner, showing against the present petitioner under section 489B/120B of the State Penal Code, showing the present petitioner as an absconder, column number.
No, my lord, I'm not shown as a absconder, my lord. I'm shown as a accused, my lord, in 3, my lord, page 22, my lord. I've been shown as a accused, my lord, accused number 3.
Then summons were issued.
No, someone is, I appeared for some time, my lord. Thereafter, the copy has come, my lord.
Okay, that I was
Since 8/5/2019, he has not appeared.
what the present petitioner, not me, present petitioner, and the petitioner appeared before the court, before the trial court, after receiving the summons from the trial court. However, in the meanwhile, due to intervention, due to COVID-19, the court work where the work of the court were affected and the petitioner defaulted in appearing before the court, and non-bailable warrant of arrest were issued against the petitioner initially on by order dated 8/5/2019 and thereafter by subsequent orders non-bailable warrant of arrest were the last order whereby the trial court issued non-bailable warrant of arrest was on 29/11/2000. Where is that order?
Page 54, my lord.
Fixing
4th of January, my lord.
4th of January as
Present.
next date of appearing. Then it comes. Now, why you defaulted?
My lord, he was working as a worker in Apartheid, Arunachal Pradesh, and he is some technical issue. There is some communication gap between the advocate and the.
Our learned, not our learned counsel for the petitioner had submitted that the petitioner had gone to Arunachal Pradesh for his livelihood and he was also suffering from some debt and had and due to communication gap with his engaged counsel, he could not appear before the learned trial court on the date fixed by the state court. It is further submitted by learned counsel for the petitioner that the petitioner is now ready to cooperate in its trial and regularly, and he shall regularly appear before the learned trial. However, as a pending non-bailable warrant of arrest, as a non-bailable warrant of arrest has already been issued against him, he seeks for some interim protection so as to facilitate him to appear before the trial. Yes, but
Otherwise, my lord, it cannot be said that he is not at all aware about the order of the, my lord, trial court, because, my lord, in earlier he appeared and thereafter suddenly, my lord,
yes,
from
he has
2009, he has.
learned counsel, learned additional public prosecutor submits that as on several occasions since 2019 to 2023, the trial court has issued non-bailable was the case of the session case number 21/19 was fixed. Therefore, it may not be believed that the petitioner was not aware of the dates. However, considering the fact that the petitioner is ready to appear before the Senate trial court and face that Senate additional prosecutor does not oppose it, affording an interim protection to the petitioner. Considering the submissions made by the counsel for both the sides, as well as considering the facts and circumstances of the case, the petitioner, namely, is the name,
Wilson Brown Borgham.
namely Wilson Brown Borgohain, is hereby directed to appear before the Court of Learned Sessions Judge number 1, Kamrup Metro on 4/11/2023 without fail and to cooperate in its trial. In order to facilitate his appearance before the learned trial court on the next date fixed, the operation of non-bailable warrant of arrest issued against the present petitioner by the learned trial court shall be kept in abeyance till that day. This of the criminal
But in this case, the petitioner to proceed challenging the proceeding, complaint proceeding, pending for the SDM one method. It is under an act. The entire matter is of the civil proceeding of the going on method. To find
whether there was a dishonor of check or
figure or check is there, but the amount has been returned back. The amount which was due has been already returned back after payment of the amount this check was dishonored. Because the security check fine. I will lost
there is no outstanding liability.
no
This plea you can take before the trial.
there is no
But if on the face of the complaint petition, some allegations are made, how we can interpret?
the amount has not been paid. And
That is your defense.
Another case is the money suit has also been filed by the complainant. It is also pending.
No, money suit can be filed,
Yes,
may be
that
filed.
can be filed.
Parallelly, both cases can go on.
But the matter is of a civil dispute. And in the similar circumstances, the Supreme Court has already set aside the
We are issuing,
in the meantime,
no, it, no,
NDPS has been
no, for that there is some other. Here, interim relief would be considered only after hearing the
the tenable date.
no, for saying you must have some ground.
Document finally see the three check here file fee
No, from what
content cases.
you have submitted, what I understand is that you have already paid back the fund. But that is the that the face of the complaint, the allegation of state counsel is made.
Well, check was disorder. That is true.
We will consider your interim prayer only after hearing the complaint.
And
Mr.
already NPW has been issued.
No,
So,
for NBW, you have another, some other relief.
Yes.
Heard Mr. I.H. Soikia, the counsel for the petition, also heard Mr. P. Botak, the petitioner for this application, the section 480 of the Court of has been filed by the petitioner Rajdeep Mia, praying for quashing of the complaint case, proceeding of the complaint case number 1606 2020 under section 138 of the Chennai Act, 1881, which is pending before the Court of Learned Judicial Magistrate First Class Learned Counsel for the petitioner has submitted that though the check issued by the present petitioner has been dishonored, however, same was issued as a collateral security and no outstanding liability was there against the complainant by the present petitioner, and hence has submitted that the proceeding under section 138 of the Judicial Act does not apply. Issue notice to the respondent. The learned issue notice to the respondent. The petitioner shall take steps for issuance of notice on to the respondent by registered post with AD to the respondent number 1 by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. As regards respondent number 2 is concerned, as the additional public prosecutor has cleared for respondent number 2, no formal notice need to be issued against respondent. The prayer for interim relief shall be considered only after service of notice is completed instead of. For that you have other. Let us hear the other side of. After that. After. May I please? This criminal petition is filed for quashing of the FIR. What happened in this case, my lord, before going to FIR, may I state the fact? My lord, in the Jhaji Jorhat section, my lord, there is conversion of road from 2 lane to 4 lane is going on, my lord. There is one half-constructed bridge, my lord, which is under construction. On 17/5/2023, at about 11:45 p.m., my lord, one accident occurred and a vehicle, my lord, by ignoring the diversion, went into that, my lord, half-constructed bridge, my lord, and the person who was driving the vehicle died. Thereafter, my lord, what happened? The brother-in-law of the deceased has lodged one FIR, my lord. Police inspected the site and officer in charge found that this is a case of drawing. Therefore, UD case was registered. On 18 also, my lord, the Deputy Commissioner Jorhat has constituted one inquiry committee to inquire into the matter. Inquiry was conducted on the same day report was submitted, and it is forwarded to the officer in charge of Chief of Police Station with a direction to take necessary action under appropriate provisions of law against the NHI DCF officer. My lord, petitioner before your lordship is a, my lord, team leader come authority engineer. His job is, my lord, to coordinate between the contractor who is constructing the road and between the authorities. The document kindly first come to the UD case, my lord, that is at page 62. Page 62 is the first FIR, my lord. 62. But this is lodged by, my lord, Pritam Gogoi. He is the brother-in-law of the deceased, my lord. May I read? This was lodged on 18/5/2023
most respectfully, I beg to inform you that yesterday, while my brother-in-law, Bhaskar Burman, was proceeding towards Jorhat from his workplace, Nazira ONGC, in a vehicle number so-and-so, and at about 11:45 p.m., when he reached near Jaguar Bridge, the vehicle fell down in the slope of Jaguar Bridge and he died. Therefore, you are requested, my lord, then this is registered as duty case. Then, my lord, the officer in charge report, lordship will find at page 64. Page 64, my lord, the last part from the bottom, my lord, how cause death and hour of death, my lord. Drowning on 17/5/2023 at 11:45 p.m. My lord, this is the first information, my lord. Then, my lord, what happened? The Deputy Commissioner has directed that FIR is at page 67. Page 67. Merit. My lord, this is the FIR I am certifying. My lord, this is dated 18/5/2023, my lord. Sir, with respect to this subject been cited above and the order under reference, it is mentioned here that an accident had occurred at Jaguar Kiosk on 17/5/2023, leading to the death of Sri Bhaskar Burman. Accordingly, District Magistrate Jorhat have instituted an inquiry committee by order number so-and-so dated 18/5/2023. Under reference above, accordingly, the committee has submitted the inquiry report, and I am directed to forward here with the inquiry report for initiating action against NHIDCL authorities as per appropriate provisions of law. Then, my lord, this FIR is registered as a, my lord, COPS case number 93 of 23 under section, my lord, 188 304 34 IPC, read with section, my lord, 51B, 55(2) and 58(2) of the Disaster Management Act. With regard to the lordship thing, my lord, two FIRs are lodged. First is registered as duty case, then second is a COP case. My lord, with regard to this petitioner, my lord, his appointment letter is page, my lord, NHIDCL, what is referred is the National Highway Infrastructure Development Corporation, my lord, the Government of India Enterprise. And my lord, this petitioner's appointment letter, lordship will find at page 19, 19. He is, my lord, team leader cum senior highway engineer. My lord, with regard to the incident, my lord, the contractor who is doing the contract, he has submitted one report, my lord.
And now, on what ground you are paying for?
My lord, first ground is, my lord, this FIR under challenge, that is the second FIR, my lord. And second thing is, my lord, this petitioner before a lordship, he is the team leader cum senior highway engineer. He has nothing to do with the, my lord, how the construction is going on, my lord. There is a report which says that, my
But
lord,
you are not named in the.
no, not named. Section 41A notice is issued to the petitioner. He has appeared, his statement was recorded. I have also filed bail petition. The court has granted the effective bail, my lord. Court has already granted me
No,
bail.
okay. Then on what ground you have paid for, you are approaching this court for watching?
My lord,
One is that this is the second.
second FIR. Second is, my lord, he is the team leader cum senior highway engineer. My lord, even if at first this is a case of negligence, he is not the project manager, my lord. The person is there to look after how, where the signage is there, my lord, how the construction.
No, but now investigation will reveal everything.
Yes,
Yes, my lord, I am not saying, praying for a stay of the investigation. At least the state lordship may issue notice and, my lord, call for the scan copy of the case, that is the Modi case. Whether I am involved, because he is the team leader, my lord. He has nothing to do with, my lord, if there is any signage or not, if whatever is there.
No. Before that,
first of all,
one ground
yes.
may be looked into
Yes.
regarding two FIR.
First of all, my lord, this is not my lord second FIR. First FIR is lodged by the my lord, brother of the my lord victim. He informed about the day after inquiry, my lord. This FIR is lodged by my lord. That is after conducting inquiry into the matter. This FIR is lodged by the my lord, ADC. So this is not a case that this is second affair.
Well, with regard to the same accident, my lord, this is not that
Same
they are
accident?
different accident, same accident. Nothing different. My lord.
Okay, let us see whether this is second affair.
My lord, with regard to involvement and fabrication,
Suspect.
What is the stage?
but investigation is going on as per my.
Case diary may be called for.
Scan copy.
It can original case diary. my lord.
Originally, if we call, then
Yeah.
it will halt the.
Yes.
The scan copy of the case that in both my lord UD case as well as this.
Heard Mr. A.K. Gupta, learned counsel for the petitioner. Also heard Mr. P. Botha, petitioner. This application under the 482 of the Code of read with Article 27 of the has been filed by petitioner, namely Manoj Kumar Singh, praying for quashing the affair. Prayer is for quashing the affair.
Yes.
Quashing the affair. Affair dated. Which is the date?
18/5/2023.
FIR dated 18/5/2023, filed by filed by Sri Damodar Burma, 8, ACS, ADC and CEO DDM Bihar. The basis of which DOPS case 93 attachment. When a counsel for petitioner has submitted that as regards the same incident, an earlier FIR was also filed on 18/5/2020 by one Pritam Gopal, on the basis of which duty case number 6/2020. Let the notices be that you will appear for both the respondents.
Yes.
Second one,
No. Yes. No, my lord. I am only appearing on behalf of one. my
has learned additional appeared has appeared for respondent number 1, no formal. However, as respondent number 2, who will represent the
Government. Otherwise, my lord, personally, my lord, by name, he made party the respondent number 2. So notice has to go to my
Notice it.
but he lost the affair in the capacity.
that permanent pocket Assam will represent respondent number.
You can also let we are
Yes.
issuing notice.
Yes.
As regards respondent number 2 is concerned, petitioner shall take steps for by registered post regulating within 3 days from date of the order return in the last court. Let this scan copy of the case that is COPS 93/26 court for along with the scan copy of case record of UD case number
6/20.
6/2020. Who will bring? You have to.
Yes.
The, the additional purpose for the ensure production of the scan copy. deposit of officer in charge of your that metropolitan report. Public.
This is the lordship. My court petition is petition. And petitioner is facing trial.
12 my lord, may kindly be taken up after some time, my lord. Lord and Deputy, my lord, KK Parasper has done for the LCR. Certainly,
13 after something. Thirteen or 14?
Item number
13.
no.
FSL has not arrived.
Your lordship may kindly fix it on my lord 12-1. I will, and I may be allowed to return back the case there. My
Third Miss R. Deka. What is your name?
El Sultan.
Third Miss El Sultan. El Sultan and the counsel for the petition also heard Mr. P. Botakur, learned additional public prosecutor, who submits that though the case diary has arrived, however, it is without the FSL report. FSL report would be necessary.
Yes, ma'am. Otherwise, my lord, today. Anyway, my lord, I may be allowed to return back the case there. My lord. If received, then police will file charge sheet.
The FSL report and let this matter be set again
PTL. Then on 19-1, my lord.
on 19-1 for FSL report. Let the case diary be returned back and to be called back again after updation along with the FSL. Let this big case be fixed on 19.
Right.
Then number 14, my lord, case diary not received.
None appears for the petition of court. The petition to prosecutor submit that the case diary which was called for has not been yet received and prays for another date for producing the case diary. The prayer is allowed. Let this matter be set again on
On my lord, 12-1.
12-1 for case diary.
Wait, please. Coordinate bail petition. The petitioner beyond the bar last 23 days. FIR is phase 9, my lord. Illusion, my lord, 379, my lord. Motorcycle already been recovered,
379.
my lord. Motorcycle already been recovered, my lord.
You are behind the bar for 23 days.
23 days, my lord.
And apart from recovery of stolen article, what other submission?
FIR is phase 9, my lord. At the time of Naga taking post, my lord.
No. Okay. Better.
So he failed to produce any document at that point of time, or till now also, my lord. My lord, who is the owner? That also, my lord, he has not disclosed.
But I am the passes for one taken and back to room, my lord. I am stating in paragraph number 5, my lord. But
Those things are not available in the case.
petitioner had purchased a second-hand motorcycle from second-hand motorcycle showroom at Nam Daboka on good faith without any written agreement. Owner namely Abdul Rahman. And purchased from my lord owner Abdul Rahman second-hand bike showroom.
Who lost the affair?
My lord, This is FIR
Only-
is by the
SIP
police, my lord.
police, my lord.
It is only suspected to be stolen.
My lord.
Yes, but he has failed to produce any document, and who from whom he has purchased that document, that also failed to disclose, my lord.
But there is no allegation of theft.
Theft, my lord, regarding the original owner, police has found RC one Mr. Dharman Patar, but his statement not yet taken of
But
Morila.
whether he has lost it,
But regarding that, my lord, there is nothing in the case.
heard Mr. M. Rock
This is
and counsel for also heard this application under section 439 of the Code of Procedure has been filed by the petitioner, namely Ikram Hussain, who has been detained behind the bar since 29/11 for last 23 days in connection with Muradhar PS case number 238/2023 under section 468/479/411 Act. List of acquisition in this case is that on 29/11/2023, one Arnold Dole, SI of police of SI of police had lodged an FIR before the officer in charge of Murajhat police station, inter alia, alleging that when the informant was conducting NACA checking duty on 29/11/2023 at Ambari Tiniali, one Bajaj discovered 150 motorbike bearing registration number AS 21D3245 was found being driven by the present victim. However, it was found that the registration certificate produced by the petitioner does not match with the chassis number as well as engine number of the said motorcycle, which created the suspicion that the said motorcycle was stolen motorcycle. The registration certificate shown by the present petitioner to the police was also suspected to be fake. So, the counsel for the petitioner had submitted that the petitioner had purchased one second hand motorcycle from whom you have
Second and back to Abdul Rahman.
from one Abdul Rahman and on good faith. On good faith, and he has not stolen the same from me. Neither any of person, neither anyone except police have filed any FIR regarding theft of said. The counsel for the petitioner has also submitted that the petitioner has been detained behind the bar since last 23 days without any fault of his, and each is ready to cooperate. On the other hand, learned additional purpose has produced the case diary of Murajhar PS case number 238/2023 and has submitted that the petitioner has failed show any document
document
regarding
ownership of the bike.
ownership of these motorcycle, and therefore there is a strong suspicion that they may be a stolen one. Otherwise, what is the progress?
Progress, my lord. Now police is trying to find out the actual owner of the
Motorcycle
vehicle.
has been recovered.
Motorcycle is recovered from him. Motorcycle, along with the motorcycle, he was apprehended by the police. Now
And the
police is
additional
trying to
public prosecutor has also submitted that the police is, the investigating officer is trying to locate the original owner of these.
original owner already located, trying to take his statement.
And it counts and the additional public prosecutor has investigated that has already found in his investigation that the original owner of the bike is some other person and it's trying to record statement of original. I have considered the submissions made by the council for both the sites as well as peruse the material of record, including the case diary of Rajar case number 238. It appears that though the present case was registered only on the basis of the, however, the investigation of another person found to be the owner of these motorcycles. However, these motorcycles, it also appears that the petitioner has already been detained behind the bar for last 23 days. Considering the progress made in this case, as well as period of detention already undergone by the present case, his further suspension does not appear for fair completion. Hence, the above named petition is allowed on bail of 30th security of the subject satisfaction of that new petition for judge with following the above of the bail of that
Applause. Sorry, Lordship, that 14 Lordship.
you show his
No appearance and Lordship, and it is fixed on 8, can it be on 4 Lordship, because today is the second date for case.
item number 14 shows that remaining will date.
On 4th Lordship, but today is the second day Lordship.
Fourth.
Arrested on Lordship 26/11 Lordship, nearing a month Lordship, and no, absolutely no allegation Lordship. Only the attempt was made by 2-3% Lordship. When they were arrested Lordship, it was found on their mobile. I was in contact.
Fourth.
4th Lordship.
Fourth.
Much obliged, Your Lordship. Much obliged.
16 will take up after some.
Particular
17, my lord, case diary
behind the bar last 36 days.
case diary not received.
What is the allegation?
379 only. 379, my lord.
Three.
This was showed arrest, my lord.
What is the stolen property?
Motorcycle. Motorcycle already recovered, my lord. And this was arrested on 16/11/2023
Oh,
in
on the in the first week. We have to peruse the case.
Yes,
How Mr.
36 days, my lord, behind the bar, my lord. Only motorcycle already recovered, my lord. The stolen property recovered.
habitual offender, my lord, in this case,
Heard Mr.
For
M. How
Earlier cases already granted bail, my lord. Kindly see page, my lord.
No, but
15,
in
my
this
lord.
case, recovery of motorcycle,
Shown arrest, my lord. This petition is shown arrest, my lord.
I'll produce the case
Earlier-
diary on
earlier
10-1, my lord.
Prisoner PS case now already granted bail, my lord. Kindly see page 15, my lord.
in a different case.
My lord, different case, my lord.
No, in this case, what is
In this case already recovered, my lord.
10-1, my lord. I'll produce the case diary on 10-1.
In this case already motorcycle already been recovered, my lord. Kindly see page, my lord. FIR, my lord.
no mere recovery is not.
Recovered, my lord. Already recovered, my lord.
No mere recovery may not
Yes.
be enough in some case if you are habitual of it.
In this case,
At
shown
least we have to peruse the case.
yes.
36 days.
Third, Mr. M. Hawk, learned counsel for because your prayer for bail was rejected by the court. M. Hawk, learned counsel for the petition. Also, at Mr. P. Botaku, learned additional public prosecutor, praised for another date for producing the case. The prayer is allowed. Let this case be discussed.
Not yet, my lord.
Give in the first
Yes, on my lord, 5th of January. my lord.
fifth of the
I have taken after some time. I can just like that. How's that? Yeah, my lord. But a similar matter, you know, my lord, the Tilmani Raga, he co-accused here, the yellow says granted bail, my lord, on 22/3, 22/8, 22/11, my lord. And the present petitioner, well, he is not named in the FIR. As of date, but 202 days. The Jomo has been very lawsuit order, my lord. It is exactly similar to Iso Rama. He co-accused must have granted bail, my lord. Present petitioner is not named, my lord. Allegation, his allegation is that he was with the team, with my lord, SI Tilmani Raga, my lord, and one co-accused, Riajul. He paid rupees 40,000 in his account. Here's the allegation. Fellowship fine, charge sheet 16/6, page 32.
why your prayer was rejected earlier.
My lord, during the course of investigation, fellowship also rejected my prayer along with other two co-accused.
During the period of investigation.
Investigation, my lord,
Okay.
along with two other co-accused, my lord.
Thereafter,
Thereafter, my lord, this two co-accused are also granted bail by this honorable court on 22/11. That I placed, my lord, the order, my lord. One day, 2 days as of now, my lord.
when were you arrested?
My lord, 3, my lord, 2/6. 2/6.
2623.
3, my lord. 2002, sorry, my lord, 202 days. And rest exactly same, my lord, the lordship observed in your lordship order. In Azizur Rahman is exactly same, my lord. He is also a police informer. He is not naming the FIR. He's shown the, my lord, that Tilmani Rava, the 6 houses, where is right is conducted. Exactly same, my lord. It's similar to Azizur Rahman.
Yes.
It is CBI, my lord.
CBI, the
CBI.
lawyer put the who is appearing? Mr. Harper.
Hello.
Let me stop. You can inform.
I am already informed because the price the case was listed, my lord. Immediately after coming to know that your lawsuit during court of investigation, the detective said, then on 15/12, I went before honorable court that it is already rejected. Let this matter be listed before the appropriate date. Again, it is listed differently.
Okay, we'll take it.
Last 3 days, 3 occasions, then we make an application before a raise. They are listed before the honorable.
Okay, let CBI come.
Good.
Item 20, my lord, case diary not received. He is on interim, my lord.
Mr.
RH. We are on interim.
What is your name?
RH. RH.
Mr. Karthik Choudhury. This is item number 20.
20 years.
Also heard Mr. P. Botha. Another date for
On my lord, 24 1.
24. Very important.
Earlier.
24, my lord, case diary received.
Okay, matter may taken.
How many petitioners are there?
Here one petitioner.
Have you appeared?
He appeared, my lord. Otherwise, my lord, implicating material against him, my lord. He is a ward member taking advantage of his position, my lord, in the name of providing, my lord, PMGY, my lord, house. He has taken money from the victim.
No, but he
He has appeared, statement record.
is cooperating.
Over. Statement record.
Mr. What is your?
Matter may take.
You are there.
Okay.
Mr. R. Ali, counsel for the petitioner.
We appeared, my lord.
Also heard Mr. P. Botha, an additional public prosecutor. Senate counsel for the petitioner submits that by order dated 20/11/23, the petitioner was granted interim bail by this court, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer and has cooperated. On the other hand, an additional public prosecutor has produced the case diary of the South Salmara PS case number 248/2023 and has submitted that though there are incriminating material against the present petition, however, it appears that he has appeared before the investigating officer and his statement under section 160 has also been recorded. You want him again? No such threat. He will continue to cooperate.
Yes.
Considering the fact that the petitioner has cooperated with the investigating officer and has complied with the directions of the court, the interim bail granted to the petitioner, namely Rafiqul Haq alias Rafiqul Islam, by order dated 20/11/2023 by this court, is hereby made absolute with condition number 2 and 3 attached to the said order. The petitioners have continued to cooperate with the investigating officer while on bail. With the above observation, the bail application sent by the case.
Deeply aware.
How many are facing trial?
4 lot.
Again, charge sheet has been laid against 4.
Yes.
How many are on bail?
3 lot, 3.
Only he is not on bail. You are opposing.
I have filed my written opposition.
What is the ground for?
Ground is lordship, he is one of the recipients money which has been extorted. He received 60,000, 40,000.
Fixed.
40,000 allegation. Evidences are there, Lord. Secondly, Lordship, there is as because investigation is going on, Lord. Therefore, there is a high chance of.
No, now that investigation is still going.
Yes, pardon.
We also already discussed, my lord, that initially the CBI made an application before the landed court below to extend further time to carry out the investigation. Then it is given.
That was
Further
allowed.
investigation.
Yes,
Yes,
further investigation.
Pardon.
310, then given 311, then given 312. but not yet completed. My lord, once the final reporting file was submitted, my lord, if you want to have any, my lord, additional report, that would only be a, my lord, supplementary report.
But against the present petitioner, you have laid the charge
Yes, my lord.
Yes.
and they are facing trial.
Yes. Trial
Trial
is
is-
not yet begun.
Not yet committed, my lord. Not yet committed. Yes, that also you lordship discussed your lordship order. Because, my lord, though the present petitioner, they were in jail, they were appearing for the landed court below. Landed court below, without
Okay, okay. It is before the committal.
without committing the court, my lord, granting time to the CBI for further investigation.
Where is your objection?
By
So main ground for objection is that
He is
further
recipient of-
investigation is going on.
He is the recipient
He
of
is one of the recipients that you have already found out that he
Yes.
has.
Yes. And
Then-
further investigation is going on, Lordship, as because it has not been completed as yet. There is chances of tampering and tampering with the witness.
For the tampering and comfort, here we cannot able to clear in the entire my lord cases dealing with by the CBI. The same objection made in the other cases also. You'll also observe everything. You'll also Adiju Rahman case, whatever my learned friends submitted, that everything is there, my lord, taken into consideration by the honorable court while granting bail.
Heard Mr. FKR Ahmed, Learned Counsel for. Mr. Halloy, you have any other topic?
No, these are the only submissions.
Also heard Mr. M. Halloy, Learned Additional Learned Special Public Prosecutor CBI. This application under section 439 of the Code of Criminal Procedure for 1970 has been filed by the petitioner, namely Mojibur Rahman, who has been detained behind the bar since 2/6/2023 within bracket for last 202 days in connection with PRC case number 1626/2023 corresponding to GR case number 469/2023 with reference to CBI case number RC 05020235003 arising out of North Lakhimpur PS case number 183/23 under section 120B read with section 340/388/1995 pending in the court of learned Chief Judicial. The gist of acquisition quote from bail application number 424226 slash quote para 3. Quote para 4. Next, Senate counsel for the petitioner submitted that the charge sheet has been laid against the charge sheet has been laid against 4 accused persons. Wherever I am wrong, correct.
Yes, my
Four accused
Four
persons,
accused, 30 days in fact.
including the present petitioner,
Nur Muhammad, Azizur Rahman, Riyazul Islam, and Mojibur Rahman.
namely Noor Muhammad, Azizur Rahman, Riyazul Islam,
And Mojibur Rahman, the present.
and the present petitioner, Mojibur Rahman. And it is further submitted by the counsel for the petitioner that in the meanwhile, the other 3 co-accused have already been released from bail. And it is also submitted that though on the prayer of the CBI, further investigation was allowed by the court. However, the CBI has not yet filed the supplementary charge, and therefore the case of the present petitioner is still pending before the committed court and is not yet committed. And the petitioner has been languishing remaining behind the bar since last 202 days. On that ground, the counsel for the petitioner has prayed for allowing the petitioner to go on bail. On the other hand, the Special Public Prosecutor CBI has vehemently opposed the grant of bail to the present petitioner on the ground that the present petitioner was one of the beneficiaries of the money which was extorted from the victim. It is also submitted that as further investigation is going on, if the present petitioner is released on bail, there is every likelihood that he may hamper in the investigation
And we know what to
and may attempt to win over the witness, and therefore he prays for not to allow the present petitioner to go on bail. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on record, including the case diary of North Lakhimpur PS case number.
is very not available.
Gone through the materials available on record. Now, in his case, you are remanded on day after every 14 days. Nothing beyond.
Seventy-four witnesses cited in the church. The case is not yet submitted, my lord. There is every likelihood of completion by near.
When the charge sheet was laid,
19/8/2023. 19/8.
21/8. That is of the 21. 21/8/23.
Which is 8/30.
Huh?
8/30.
19.
19/8. 19/8. You'll also find page 26. by petition. Date 19/8/2023. Church sheet. 20.
it appears from record that though the charge sheet has been filed against the present petitioner and three of the co-accused on 19/8/2023, however, the case of the present petitioner has not yet been committed, and the learned Chief Judicial Magistrate Lakhimpur has extended the date for completion of further investigation. Till when any date is given?
No, last date was given, my lord, 12/12/2000, no, 12/12/2023.
Thereafter,
Thereafter, my lord, that I submit.
extended the date of completion of the further investigation time and again. Time and again. The petitioner has been detained behind the bar since last 202 days, and as the other three co-accused against whom charge sheet has been laid are already released on bail, unless there is some justification for his continued detention, he would be entitled to
Yeah.
get paid like that of other coins.
Yeah.
The objection raised by the present petition by the learned counsel for
CBI.
the learned special public prosecutor CBI under the facts and circumstances of the case does not appear to be good enough to allow continued detention of the present view of the fact that that other three co-accused are already released. More so, more so, as there are large number of listed witnesses in the charge sheet, that is 74 number, the completion of trial would likely to take considerable period of time, and the case is yet to be committed to the court of session. Hence, this court does not find any justification in keeping the petitioner behind the bar during this case, if he otherwise cooperates, or the reasons aforesaid, the present petitioner, namely Mojibur Rahman, is hereby allowed to go on bail of 30,000 responsibility of fine, subject to the satisfaction of the petition. Not Lakhimpur, not with following conditions, same like other same condition.
Yes,
This bail application number 4226. This bail application.
obliged. Deeply obliged.
Sorry, my lord, lordship, in regards to item 13, lordship, lordship fixed on 19th of January, lordship. Can it be fixed on 18th, lordship? Because mandatory period will be over if the taxi will not less than
18. Item number
13.
item.
Obliged.
I'm taking it.
Which is the lordship. The petitioner is before your lordship is behind the bar for last 182 days, madam. 188 days, madam. For an offence registered under section 21B of the NDPS Act, madam, for an alleged recovery of 44 grams of powdery substance from 3 accused persons, madam.
Charge sheet has been laid.
Charge has been laid, madam. It was laid on 14/8/2023, madam, and since then he is in custody, madam.
On which date you were arrested?
Madam, as for the 17/6/2023, madam, I was forwarded to the chief justice, madam.
And charge sheet was laid on
Madam, on the 14/8/2023, madam, it was
14/8.
14/8/2023, madam.
And how many witnesses?
Madam,
No, not yet, my lord.
not yet. Charges were not yet.
Last order, my lord, I have taken, my lord, 31/10/23. It is fixed on 22nd of 11. That is gone, my lord, for CC, consideration of charge.
Not same.
What is the contraband? What?
The 44 grams of brown sugar, heroin.
Yes, Mr. Bharat.
My lord, yes,
Is
my lord,
intermediate
intermediate quantity. That is there, my lord. So
and charges are
charges
Not same, madam.
maybe same, my lord, but
My lord.
it's up to that. Not is up to that, but yes.
My lord, it is 6/9/2024 for consideration of charges, my lord.
Again,
Today is their production date, my lord, for the trial court. So I have talked with the counsel over there, my lord.
How many accused are there?
There are
as
3 accused persons, my lord.
three accused and
Others?
5
Others
witnesses in the.
for not your lordship on the one accused petition.
And what has happened to
They are facing the trial. Probably they have not preferred any bail. They are in
They're
custody,
in
my lord.
custody.
Custody.
All are in custody.
All are
How Mr.
5 witnesses in the. Sarkit, my lord.
8. Yes.
Uh-huh.
8.
8 witnesses.
Third, Mr. M.A. Chaudhary, Circuit Council for Third State Differential Application under 439 of the Code of has been filed by the petitioner Nazmul Hussain, who has been detained behind the bar since 17/6/2000 in bracket for past 188 days in connection with in special NDPS case number 69/2023 corresponding other NDPS case number 1945 under section 21B/25 that the council for petitioner has submitted that petitioner has been admitting to bar since last 188 days and has been facing a trial in special NDPS case 69/2023 along with 2 other co-accused for possessing 44 grams of suspect 44 grams of heroin. So, the Senate counsel for the petitioner has also submitted that though the charge sheet was laid on 14/8/2023, however, till now, even charges are not yet framed and next date is fixed on 9/1/2024 for consideration of charges. Senate counsel for the petitioner has also submitted that since the quantity of contraband seized in this case less than commercial quantity, the embargo of Section 37 does not come into play. And since the petitioner, a permanent resident of Karimganj district, need ready the other hand
On length of detention only, my lord.
does not possess ground of does not opposes the prayer for bail on the ground that the contraband is of intermediate quantity
And
also the fact that the petitioner has already been detained behind the bar for last 188 days. Considering the submissions made by the petitioner as well as the prayer for bail is allowed, the petitioner named the Nazmul Hussain is allowed to go on bail of 20,000 with one security of life subject to satisfaction of an special judge Karimganj with for the continue that he shall cooperate in his trial and shall appear before the trial court as an public by the trial shall not direct make it to dissuade any that condition instead of in that condition last line would be so as to dissuade any person that witness from deposing against the petitioner in NDPS, special NDPS case number 69/2020. With above observation, this bail application is thereby dismissed.
May it please the Lord, 439 FIR is please 9.
Where is that page?
9.
Yes, what is the allegation?
Okay, for the petitioner number one, 22.91 gram suspected recovered.
Heroin,
Twen-
how much?
22.91 gram and
Intermediate quantity.
lordship and 6.925 gram recovered
6.92 gram.
2 gram from the petition number two lot. Today is 43 days.
41.
No, 22.9 grams from,
Petitioner number
One.
one lot.
there are two petitioners
Lot.
Two,
and
6.92 gram.
when were you arrested?
Lordship arrested on 10/11 lordship, forwarded on 11/11.
Today is how many days?
41 days. ma'am.
41 days.
But Tastit is not yet filed because FSL not yet received. Otherwise, the petitioner number one is loitering in the market and police on suspicion apprehended him and when taken to the PS and subsequently on search before independent witness
So investigation has fairly progressed.
progress. And
Only
subsequently,
waiting for FSL report.
only FSL report is required and there are seizure witness, three seizure independent witness are there. Subsequently, another person was also apprehended. Is not before us. Petitioner number one, two. So some person of drugs in his home. Is also one safety. But they are all involved. 41 days. PS not yet filed. Materials are there.
Heard Mr. M. Alam, Learned Counsel for Petitioner. Also heard Mr. K. Parachar, Learned Petitioner Public Prosecutor. This application the section 439 of the Code of Criminal Procedure of 1973 has filed by the petitioners named Juganta Das alias Hitler and number two Vishnu Prasad Begu alias Kundo, who are detained behind the bar since 11/11/2023 within bracket for last 41 days in connection with Baluk PS case number 214/20. The gist of accusation that in this case that on 11/11/2021 one Vishnu Deori, SI of Police of Bandardeva Police Outpost, had lodged an FIR before the officer in charge of Laluk Police Station, Inter-Area, alleging that on 10/11/2023, on receipt of an information through reliable sources, a search team was conducted and a search operation was and a narco checking was conducted near Harmati Market, and there the present petitioners were apprehended along with there the petitioner number one was apprehended and 20 numbers of plastic containers containing orange color powdery substance suspected to be heroin weighing about 22.91 grams was seized from his possession. Thereafter, the petitioner number 252 Satbegu was also arrested and 6 numbers of plastic containing suspected heroin weighing about 6.92 grams were seized from his possession. The counsel for the petitioner has submitted that the quantity of contraband seized from the possession of the present petitioner is less than commercial quantity, and considering the period of detention already undergone, that is 41 days, they may be allowed to go. On the other hand, an additional public prosecutor has placed the case diary of Lalu PS case number 214/2000 214/2023 and has submitted that there are sufficient incriminating materials against both the petitioner. He has also submitted that the investigation has been fairly progressed and is pending only for the receipt of FSL report. Considering the submissions made by the counsel for both the sides, as well as considering the fact that the investigation has fairly progressed and the petitioners have been detained behind the bar since last 41 days, their further custodial treatment does not appear to be necessary for fair completion of the case. Hence, the above named petitioners the petitioners, namely Juganta Das Siddharth and Vishnu Prasad Das, Vishnu Prasad Pegu alias Mukundo, are hereby allowed to go on bail of rupees 30,000 with one security of license, subject to the satisfaction of Chief Judicial Magistrate, North Lakhimpur. Chief Judicial Magistrate Lakhimpur, North Lakhimpur, with following quotation with above of the thereby.
Heliope. May I please your lordship. 438 application matter. FIR at page 12.
Earlier rejected by your lordship, my lord.
My lord, earlier
Page
it was
21,
rejected,
earlier
my lord.
rejection on.
My lord, there were 6 applicants earlier, my lord, and out of 6, my lord, 5 petitioners were allowed by this honorable court, and this petitioner was rejected. The subsequent ground is that, my lord, he was suffering from appendix pain from earlier, my lord, and recently he has been advised to admit in DMCH and go to and undergo surgery. Therefore, he is before the honorable court. My lord, in this case, there were 7 accused persons, my lord. And out of 7, number 1, Shahidul Islam, he was arrested, and after 23 days, my lord, he was released from this honorable court. And the order is at page 26. And other accused persons are released on pre-arrest bail. Only Mohrum, this petitioner, is left.
Earlier,
my humble submission is that the FIR was lost on 7/7/2023, my lord.
Why it was rejected earlier?
my lord, page 21, my lord, last paragraph, your lordship. Page 21 of the petition. Fourth line, my lord. it also appears from the case diary that there are serious incriminating materials against the petitioner, the present petitioner, my lord, Mahroom Ali, in the case diary, including the statement of the victim recorded by the investigating officer, which does not justify his release on anticipated bail at this stage of investigation.
What was there against him?
Victim also implicated.
What was the allegation?
My lord, the allegation was that at 10 p.m., my lord, the accused persons entered into the house of the victim and broke the glasses of the house and beaten them. And the accused number 2 and 1, Sahidul and present petitioner, physically assaulted the alleged victim. This was the allegation, and case was registered under section 448, 326, 427, 380, and 354 of Act. The girl who says that physically assaulted her, she is
Now,
already
what is your
married.
ground for second bail?
My lord,
Subsequent bail.
this is second bail application. My humble prayer is that already all the accused persons are released on bail, my lord.
But
And
that cannot
substantially,
be
I
a
think,
ground.
my lord, the investigation is, I think, over, started to be filed. So, custodial detention whether necessary.
He will say whether it.
Well, otherwise, well, finding sufficient your lordship has already, there is no new ground. You will have to
My
show
lord, he is
any new
suffering
ground
from
for
he is
getting bail.
suffering from appendix pain, my lord, and doctor has advised him to undergo surgery. So he is escaping, my lord, for many days. His disease is increasing.
What is it? Where is your appendix? Show the
My
document.
lord, 20 medical certificate at least 25 months. The doctor has given advice that he have to admit in GMC. Advice given, refer to GMC. The accused person, one who has been arrested, the police did not sought police remand. Ultimately, it shows that
What has happened to the arrested accused person? He is on bail or still?
And
he
only
is
your
on
lord,
bail, my lord. It is at least
earlier
26
your
months.
lordship has granted all the earlier accused persons except the present accused, well, finding sufficient material against the present.
Now, whether you require detention.
No, I will leave it to your lordship, my lord. Otherwise, my lord, from there is no new ground. My lord, and this
His
is
ailment is the new.
ailment, my lord. This is document prescription only referred to.
My lord, it
This is not a certificate. Anyway, my lord, I will leave it to your lordship, my lord.
not at any condition, my lord, I will cooperate with the investigation also, and I will also face the trial.
Heard Mr.
Take care.
A.K. Azad, Learned Counsel for also heard Mr. P. Bordar to Learned Petitioner. This application under section 438 of the Code of Criminal Procedure, sec, 1973 has been filed by the petitioner Mahroom Ali, who is apprehending his arrest connection Boreshwar police case 124 the section 448 326 426 380 354 34 of the case. It is pertinent to mention here that this is for the second time the petitioner is approaching the court praying for his anticipatory bail. On the earlier occasion, his prayer for anticipatory bail was rejected by this court in AB case number 3028/2026 by order dated 8/11/2026. Learned counsel for the petitioner has submitted that the there are how many accused persons?
7 accused.
There are total 7 accused persons named in the affair, out of whom 5 were granted anticipatory bail by this court. accused number 1 got arrested. However, after his arrest, he was also enlarged on bail. By which court?
That's by Honorable Justice
By
Eddie
this
Chaudhary.
court, High Court.
My lord, by Honorable Justice Eddie Chaudhary.
He
In
was also enlarged on bail by order dated
7/9/2023.
7/9/2023, passed in
Bail application number 3104 of the
3104 of 2023. Learned counsel for the petitioner has submitted that his new ground for approaching this court for the second time seeking anticipatory bail is that the petitioner in the meanwhile has suffered from appendicitis and he has been referred to better treatment for appendicitis to Guwahati Medical College Hospital. In support of the submission made by learned counsel for the petitioner, a prescription issued by whom? National. Where you have gone?
My lord, it is the NHCH, my lord, National Health Mission.
A medical prescription of the petitioner has been annexed as Annexure 3 along with the present. On the other hand, an additional public prosecutor has submitted that there are incriminating material against the petitioner. However, in the meanwhile, the investigation has progressed. Why it is pending?
Well, the investigation is pending because regarding the present accused, he is not yet arrested.
And it is pending as the present accused has not yet been arrested. Considering the fact that the petitioner number 1, who was one of the main, that the accused number 1 named in the FIR, who was also one of the main accused along with the present petitioner, has already been granted bail by a coordinate bench of the court. Also considering the fact that the petitioner is suffering from appendicitis and requires urgent medical. Also considering the progress made in the investigation, the prayer for the petitioner, namely Mahroom Ali, is thereby directed to appear before investigating officer of Gorecha PS case number 124/2023 within a period of 10 days from the date of the and cooperate in the stop if he does so within the stipulated period of time, in the event of his arrest in connection with Gorecha PS case number 124/2023, the petitioner shall be allowed to go. The above named shall be allowed to go. Bail of 30,000 one security of title subject arresting authority with following.
Hello.
I'm sorry, my lord, I was not there on time. My lord. With all respect, my lord, it relates to Railway Property Unlawful Possession Act. Here, my lord, with all respect, my lord, FIR is at case 17. To the totality, my lord.
Yeah.
I'm sorry, my lord, I'm taking a minute. It reached, my lord, huge quantity of railway material were being removed, my lord. And there, my lord, with all respect, my lord, all these offenses are, my lord, slab is 5 years, my lord. If you look about Tanda page 18, then 19, my lord.
the FIR states regarding removal of railway properties, my lord. And 19, if I read, my lord, reading between the lines, Lordship would kindly find brief of the case. Lordship has found, my lord. Page 19, my lord. Second paragraph, my lord. There's the forwarding report, my lord. Brief of the case, my lord.
This is the forwarding report.
Yes, my lord.
Oh.
The brief of the case, my lord. They are reading aside 510 lines, my lord. That the railway materials were loaded without the knowledge of the above trailer. On being in, this is the language, my lord. Inquiry, they met her with the driver of the state trailer, the short namely Hazarat Ali. He goes on and on to say, my lord, that railway materials were loaded onto his truck, my lord. Now I turn the page. The major part comes out, my lord. Page 20, my lord. One page, my lord. During inquiry, EO of the case observed all the necessary formalities and examined and recorded the confessional statement of accused Hazarat Ali, where he admitted and confessed his guilt. On 29/1 so-and-so of the case, my lord, produced the accused person, namely Hazarat Ali, so-and-so, and remanded the accused Hazarat Ali to, my lord, 4/12/23. It goes in and on, my lord, on the next paragraph. This is important, my lord. On 30/11/23, the EO of the case interrogated and recorded the further confessional statement of remanded accused Hazarat Ali, where he admitted and confessed that he is a habitual carrier of such railway material and already carried such type of material earlier on huge monetary benefit, and showing the challan provided by party to concern according to requirement. On 28/11/23, he came to Panikhai to carry the railway iron material. On 28/11/23, the person who signed before him, this is the language, my lord, and me on the seizure list, he was present at the time of loading the iron railway material into the trailer, and he knows the person as Gias. Now, Gias is before your lordship, my lord. Gias, my lord. The remand of accused also confessed for 2-3 days before he also carried the same railway material from the same spot, and the said person, namely Gias, was also present there. My lord, my involvement I am showing, my lord, with all respect, my lord. While the railway materials were being loaded, my lord, the accused before your lordship, he was present at the place of occurrence. My lord, the first page would show he was initially contacted by 2 unknown phone numbers. And thereafter, my lord, with all respect, my lord, the forwarding report states, my lord, next page, my lord, 21. 21, first paragraph, second paragraph, third paragraph, my lord. On the basis of leading statement of accused Hazarat Ali, meaning thereby the driver, my lord, regarding involvement of Ghiasuddin Ali, now he is before your lordships, into the case, and during loading of trailer number so-and-so, he was present at the spot and supervised the loading. On 2/12/23, on being called, Ghiasuddin Ali attended, my lord, this is very important, my lord. My antecedent, my lord, he was present at the spot and supervised the loading, meaning thereby the present accused before your lordships, my lord. While commission of railway property theft was being carried out, he was present, my lord. On 2/12/23, on being called by the railway authorities, Ghiasuddin Ali attended RPF post so-and-so. Asking, he admitted and confessed his guilt before me. On the basis of his confession, he has been taken into custody, and intimation regarding his arrest given to his wife over mobile phone. Now, my lord, with all respect, my lord, when he was called, what I am trying to prove, my lord, when he was called, he immediately appeared, and thereafter he was arrested. His antecedent, my lord. And secondly, my lord, these are all slavish 5 years, my lord. Even that, my lord, quantum of punishment at the end of trial, if convicted, it can be less than 1 year old. Why I am saying this, my lord? In this scenario, my lord, I'm sorry.
Amnesh Kumar is not.
Exactly, my lord. This is, they inform the old formalities, my lord, informing the family members, my lord. But Ernest Kumar has been given a goodbye. That will come later on, my lord. He has been given a goodbye. Now, my lord, how I am related to this railway, my lord, property business, my lord, with all respect, my lord. Just I'm taking 2 minutes, my lord, with all respect, my lord. Lordship would kindly have a look at, my lord. I have shown the FIR and the forwarding report that I appeared, my lord, with all respect, my lord. I was taken to police remand for 4 days, my lord, with all respect, my lord. Now, my lord, Lordship would kindly have a look at page 29.
Yeah.
Page 29. This is a deed on agreement between two railway contractors, my lord, Sopon Kumar Ghosh and Shankar Asaria, my lord. Next page, my lord, with all the site is the same, my lord, page 30. Whereas the first party, it goes on and on, my lord. These 35 RCC box segment, in this from this segment, the railway property theft, whatever was committed, my lord, was committed. This is an agreement. Thereafter, I entered into an agreement with him. That is at page 40, my lord. This is the agreement, my lord. Then I gave note page 40, my lord. There is, my lord, with all respect, my lord. This is by me, my lord. My advocate has served the notice on Sopon Kumar Ghosh and Shankar Asaria, the site contractors, my lord, whereupon the railway materials were stolen, my lord. To be very honest, my lord, I turned the page, my lord, page 41, clause 1, my lord, that you entered into an agreement with my client, Ghiyasuddin Ali. This way, Ghiyasuddin Ali came into the picture because he was given subcontract. There was some dispute, my lord. Thereafter, my lord, with all respect, my lord, they replied, that is at page 44, my lord. I'm taking a minute, my lord. Why, my lord? How I am related to this? Page 44, my lord. They replied, my lord, by engaging lawyer, my lord, to me, my lord, with all respect, my lord, that page 47, my lord. Kindly have a look at para 6, page 47, leaving aside 5 lines from the top, my lord. Page 47, my lord, reply by, my lord, the present contract, principal contractors, my lord. Page 47, para 6, leaving aside some lines from the top, but your client has miserably failed to complete the work. As a result, my client had to complete the construction or a bridge so and so. My client does not admit that he owes an amount of rupees so and so. And he thereafter, my lord, they took over the construction work, my lord. And thereafter, a civil suit is also pending, my lord, between the prime contractors of the site, whereupon railway properties have been stolen. That is at page 49, my lord. We have been served notice, my lord, title 106/23. We have been served notice, my lord. Thereafter, again, page 53, my lord, para 6, my lord. The same has been reiterated, my lord. That they took over the construction, my lord. The parent railway contractors, my lord. Now, my lord, a letter has been given, served on them by the railways, my lord, with all respect, that is at page 58, my lord, to remove the, my lord, with all respect, my lord, sheet piles, my lord, those which have been allegedly stolen, my lord. This is to, my lord, Sopon Kumar Ghosh, the parent contractor, with whom I am having a, my lord, legal tussle, page 58. This itself shows, my lord, regarding the removal order, my lord.
What is this?
My lord.
What is page 58?
Page 58 is a letter from the railway authority to the parent principal contractors, my lord. I was a subcontractor, my lord, for removal of those.
With whom you have a civil suit?
Exactly, my lord. This is the notice, my lord. They were removing. I was brought into the picture, my lord, because there was an outside court settlement that some amount would be paid to me, my lord. So it is a fact, my lord, I was present at the place of occurrence, at the time of occurrence. Regarding removal, my lord, if that is theft, I am a party to it, my lord. I do not deny that, my lord. Now, my lord.
No, but they were directed to remove the Material by the railway authority as per
Absolutely,
Yes.
absolutely, my lord. As per their instruction, the removal part, I was present, I signed on the seizure list also. Just a factual matrix I am placing, my lord. Then I'll come to the offense, my lord. Page 59 is the seizure list, wherein I have signed, my lord. The date of occurrence, my lord, 28/11/23, and down below, my lord, Giyasuddin Ali, serial number 5. I'm trying to place one thing, my lord. If illegality is committed, my lord, I'm a part of the illegality, but not the total illegality. Because I signed as a witness. First of all, my lord, these are the factual metrics, my lord, and regarding removal, in the Railway Property Unlawful Possession Act, my lord, even provision of bail is there given to the railway. Why I am stating this, my lord? Whether my custodial detention is necessary or not, my lord, I am therefore after 4 days in police custody, 20 days thereafter in judicial custody. Now, my lord, in the Railway Properties Unlawful Possession Act, my lord, with all respect, my lord, Section 8, my lord, inquiry how to be made, and thereafter, my lord, in the said act, my lord, with all respect, my lord, officer in charge of that railway RPF post, my lord, he is also has been given the power to grant anybody the privilege of bail. Because it is RPF property. That is in the same book, it is at page 111, my lord. May I just place this? My lord, there it is to be read, inquiry how to be made.
Yes.
Meaning thereby, offences under the Railway Property Unlawful Possession Act, the power of bail has been vested with the investigating agency also. It is not that I have been granted that privilege. I am not saying that, my lord. The offences are of that nature. Have I made my position clear, my lord? Now, in this scenario, my lord, with all respect, my lord, that until, because that paragraph is apparent, my lord, family members were involved, and I appeared when they call me, my lord. It is not that I'm not a law-abiding character, my lord. And I'm there for 20 days, and most of the materials have been seized by the investigating agency. And until, for the sake of reiteration, my lord, I should not, my lord, but I'm reading just a single paragraph, my lord. When in a case where the quantum of punishment is touching 7 years, my lord, in that event, my lord, with all respect and folded hands, my lord, until needs to be followed because of Article 141, my lord. The law laid down by the Supreme Court shall be followed by all courts toward the territory of India. The railway magistrate wherein he was produced, my lord, never followed, my lord, with all respect, my lord, the dictates of until, my lord, and until para 73, my lord, regarding the bail part, my lord, with all respect and folded hands, my lord. See, my lord, the court will have to satisfy, meaning thereby the railway court themselves on the compliance of section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail. This is, my lord, a constitutional mandate, my lord, not statutory, my lord. And thereafter, my lord, following this, my lord, there are some authority, my lord, authorities of our High Court, my lord, that we have annexed to the application. That is at, my lord, page 62, page 61, my lord. Page 61, my lord, with all respect, my lord, that occurs at page 62 and the last parting paragraph, my lord. Merely on non-compliance of until, my lord, and page 63, third paragraph, my lord, on non-compliance of SK until, my lord, the privilege of bail has been granted. Another order I have annexed, my lord, consequent to, my lord, passing of the order in the until case, my lord, page 65, same, my lord, that is also the operative part, is at page 67, para 7. My prayer is this, my lord, law has been violated in totality. I am there for 20 days. I was a law-abiding citizen, is a law-abiding citizen, and I appeared voluntarily when being called. Until was violated, and my lord, I was given 4 days police remand. Thereafter, my lord, in judicial custody, whether my father custodial detention for the sake of investigation is necessary, and most of the materials have already been seized by the investigating agency from other parts. This is our case.
Lordship, already my learned senior had told that his presence is there, Lordship. Now, what his confessional statement, Lordship? His confessional statement, although stated that about the civil suit, etc., Lordship, but few things is that it is not that he is acting as a subcontractor, Lordship. Lordship, I am reading from this case diary, Lordship. Due to the above, he suffered huge financial crisis. 1 month ago, he came to know that the work of RUB construction has been concealed by railway authority and seat piles were staked near the railway kilometer 21/9 on railway lane in between Narengi Panikhati railway station. Then he decided to sell the stake seat pile for recovering his loss. He planned with some other known people and ensure lifting of railway seat pile in his presence from railway land near Shiv Mandir of Panikhati and Thakurkusi in last 10 days with help of Hydra and private labor and given to known person for his monetary benefit. We will not disclose their name, even though on 2011-23, while an auto driver was handing over the fake road salan and authority letter to driver, namely Hazrat Ali, who had arrested by me during interception on the above truck driver, he interfered and given Sans auto driver to play away because he had feared that if the auto driver, who is well known to him, will catch by police, then his plan fraud for theft of railway material will be exposed. This is his true statement given before me without any fear, pressure, greedy or mental harassment or threat or inducement. He understood properly and accepted as correct and put his signature. So, and one person who is also arrested called Jyotirmoy Sharma, Lordship, he is associated with the temple where actually those stolen materials were first kept there, Lordship. And then during when these were shifted, it was seized by the police, Lordship. And according to him also, Lordship, he had some persons came introducing themselves as a railway official to shifting those materials. Subsequently, this present petitioner had himself told that actually they are not the police official, Lordship. So, persons, Lordship, may I read his Lordship? Thereafter, they took away the material, Lordship.
No, that means there are materials against that you want to say. There are materials against the present.
Yes, Lord.
Now he has been detained behind the bar.
From second. Lordship.
Now
And
further detention is
Lordship, yes, Lordship. I have in my forwarding letter, they have requested a further investigation because on 2 days back on 2023 also he was interrogated because there are involvement of some other persons are there. Especially they have stated that 3 persons are there, Lordship. But till date he had not mentioned their name. And all the stolen materials also not fully recovered. So there are some other materials are there, and he had till date he has not mentioned the names of those 3 persons.
okay. That means further interrogation.
Yes, Lordship. Yes.
Then what is your response regarding non-compliance of permit? No 41 notice was given. He was called to the police station
Lordship.
and he was arrested. Without, though the offences are under 5 years, the punishment prescribed for all offences are 5 years.
5.
What are the offences?
My lord, PA, my lord, 5 years.
Only one.
One.
So Anish Kumar, on that any submission? He will appear if interrogation is required. Even after bail, you have interrogate during his custodial interrogation.
Lordship, today is his 21 days only, Lordship. So perhaps Lordship further investigation, yes, sir, 2 days back also, but he had still did not stated. So after bail, there is.
Every day will appear if necessary.
But his involvement is there, Lordship,
Yes,
and there are material against him also.
Regarding
Lordship.
involvement, I myself has admitted, my lord, my involvement is there.
Anything else? Okay, I- it was also be sure that council for within a Learned Council for the this application 439 Court of has been filed by the petitioner Giyasuddin Ali, who has been detained behind the bar in 2012 2015 within bracket for last 20 days in connection with RPF slash PO post slash NGC case number 28 slash 2020 under section 3 within bracket A of the Railway Property within bracket Unlawful Possession Act, Unlawful Possession Act 1966. The gist of accusation in this case is that where is the FIR?
Page 17.
That on 28/11/2023, the senior section engineer within bracket work NFL with Jagirot had lost the FIR. What is IPF NGC?
IPF.
FIR is addressed to IPF.
No, it's not IPF, not Guwahati. New Guwahati. New Guwahati.
Oh, New Guwahati.
My lord, New Guwahati. There's an RPF post there.
What is IPF?
IPF. Yeah,
It is not RPF.
Oh, it was IPF. IPF.
IPF slash NGC NFF, comma, inter alia alleging that.
Inspector,
no.
IPF.
No, I'm mentioning it as it is.
My lord.
IPF NGC NFL, comma, inter alia, comma, alleging that during the station visit made by the first informant, a huge quantity of various types of sheet piles were found to be stolen and loaded in a trailer number NL01AB 5586. On receipt of the said FIR, RPF slash post slash NGC case number 28 slash 23 under section 3A of the Railway Property Unlawful Possession Act, within bracket Unlawful Possession Act 1966. The counsel for the petitioner has submitted that the only allegations made against the present petitioner in the forwarding report, while he was forwarded before the Court of Special Railway Magistrate First Class Guwahati, is that the, when the railway materials were being loaded in the trailer, the present petitioner was also present there and was also present there. and was supervising the loading of the which is submitted by the where is the order of the coordinate bench regarding non-compliance?
Well, that is it. Page 61. And the operative part is at 62 and 63 in between.
Learned counsel for the petitioner has submitted that on 2nd of December 2023, the petitioner was called to attend the RPF post NGC, and when he appeared before the said RPF post, where you went?
Well, that I'm reading now.
From where you were arrested?
From the office itself, my lord, page 28.
Office of the what?
The office to correct. I'm
You-
taking a minute, my lord.
From where you were arrested?
My lord, page 21, para 3, my lord. Attended RPF post, page 21, my lord,
RPF
third paragraph.
/ post / NGC. What is this?
That I do not know. এটা কি হবে? তোমার sorry, my lord. But it is in Guwahati, my lord.
No, is it a police station or is it
It's an RPF police station. RPF is police station, but railway is not.
RPF / post / NGC? He was arrested and there it is stated that he had made confessional statement. Learned counsel for the petitioner has submitted that before arresting the present petitioner on 2/12/2023, 12/2023, no notice under section 41A of the Code of Criminal Procedure, 1973 was issued to him. Therefore, it is submitted that there has been a violation of the guidelines issued by the apex court in Arnesh Kumar versus State of Bihar and another reported in 2014 8 SCC 70. Learned counsel, wherever there is a violation of the guidelines made by the apex court, Arnesh Kumar case, if only or if court of such not compliant to the cited for not
Mile.
for support of submit that the council has not cited a ruling of the apex court in Satinder Kumar Antit versus Central Bureau of Investigation reported in 2022 SCC online SC 8 Learned counsel for the petitioner has submitted that the max, what is the punishment?
7 years, my lord, for until, but here 5 years.
The maximum punishment prescribed for
3A.
prescribed under section 3A of the Railway Properties within bracket Unlawful Possession Act 1960 is 5 years. Therefore, the guidelines of the apex court would be applicable. that petitioner has already been for last 20 days. He means that where and it is ready to cooperate. Further, it also submitted it also submitted by that that the that that and you have it.
Everyone is self-put.
On the other hand, learned counsel for the legislature has submitted that there are sufficient material as present while making its confessional statement before has admitted that it, under his direction that the railway materials were picked up from where it was from the site from where it is located. So,
This is Narengi Panikhati railway
why
station.
he has picked up compensate
No, he has incurred financial loss, and that is why he has stolen this.
to, to compensate the financial loss suffered by the presentation. He intended to sell the railway property. Senate Council for the Railways has also submitted that some other co-accused persons are also involved in the case who are yet to be arrested, and further custodial detention presentation would be required in this connection. Therefore, he opposes the grant of bail. I have considered the submission made by the council for both respects and have gone through the materials available on the. In this case, it appears that it is apparent that the petitioner has been behind the bar since last 20 days, and his statements were recorded on more than one occasion.
Yes, yes.
On more than one occasion by the investigator. It also appears from the, you have the case diary. It also appears from the case diary produced by the counsel for the railway that the IO has failed to comply with the provisions of Section 41A of the Code of Criminal Procedure, and as observed by the apex court in the case of Satinder Kumar Antit Supra, that in paragraph number 73B of the said case, that if that the investigating agencies and their officers are duty bound to comply with the mandate of Section 41 and Section 41A of the Code of Criminal Procedure 1973, and the directions issued in this regard by the apex court in Anesh Kumar within Becks, and any non-compliance would entitle the accused for grant of bail. In the instant case also, considering in the instant case also, as there appears to be total non-compliance of state aforesaid crime, as well as also considering the fact that the petitioner has been detained behind the bar for last 20 days, during which he was examined more than once by the investigating officer. And if he continues to appear before, continues to cooperate with the investigating officer, his custodial detention does not appear to be for fair completion of investigation of the case. So, in view of the above, the petitioner, namely Gyasuddin Ali, is hereby allowed to go on bail of what should be amount?
Larger amount of
50,000. Bail of 50,000 with one surety of like amount to the satisfaction of done at special railway station. Who will
My lord, with all respect, my lord, Court of Special Railway Magistrate, first class, Guwahati, NF Railway. Page 26, my lord.
with the above of the with where the
Highly obliged, my lord.
Lordship,
Obliged.
cooperate with the investigation, Lord.
with following in with following condition. Number one and number two. He will not make any inducement, threat, or promise, and he will cooperate with the.
May I take you, Lordship? This petitioner is a Lordship, actually is a drug distributor, Lordship, having valid trade license, Lordship, GST number. That Lordship will find on page 25 onwards, Lordship. 25 to 29, Lordship. Now, Lordship, may I take you to the FIR, Lordship, first. That is on page 17. Lordship, got it? May I read, Lordship? With due respect and humble submission, I have the honor to report that that an information was received from the reliable source by the OC Choigaon PS at around 10 a.m. that 3 drugs peddlers are coming from Guwahati towards Gwalpara side via National Highway 17 in a small maroon color vehicle bearing registration number such and such to sell narcotics drugs in a different parts of South Kamrup district and its adjacent district, no specific logic. Accordingly, a GDNT was made in this regard by OC Choigaon PS, by Choigaon PS GDNT number such and such, and endorsed me to conduct a NACA checking in front of a Choigaon PS. Thereafter, I, along with OC Choigaon PS and staff, left for NACA checking in front of the Choigaon PS at around 10 a.m. Intercept the aforesaid mentioned vehicle from 10:15 a.m. NACA point was installed in front of the Choigaon PS, and I, along with the OC Choigaon PS and staff, started to check the suspected vehicle. Accordingly, at around 10:50 a.m., the above mentioned vehicle, that is one maroon color small vehicle bearing registration number such and such, was intercepted, and 3 suspected drug peddler, namely Shahil Hussain, son of such and such, the village Mathun Golapatti, Imphal, district Imphal, is East Manipur, and second John Chaudhary, and son of such and such, and 3 Shah Nawaz, son of such and such, and prompted to be apprehended. Then the information regarding the matter was shared to the Superintendent of Police Kamrup Amingao for a favor of the kind information. Then I approached the below mentioned witness, requesting them to remain present at PO witness the search operation. They were also explained the purpose of search. Then, Lordship, the name of the persons were given. Accordingly, after last paragraph, Lordship, accordingly, after the arrival of the witness, DS Deputy SP Kamrup and PO at around 11:40 a.m., I, along with the staff, searched the vehicle and found 10 numbers of plastic vials contain yellow colored powder substance suspected to be heroin, which were hidden under the floor mat of the front passenger seat of the intercepted car. The plastic vials were weighted in front of the witness and found it is 20.62 grams. That is the container. The plastic wells were then marked as an A1, A2, A3, A10 respectively.
8.22 grams of heroin.
Only 8.22 grams of heroin. Now, Lordship, they said on interrogation, they said, Lordship, the Lordship, middle part, Lordship, after arrival at a PS on interrogation, one of the apprehended persons, Shah Nawaz, he revealed that he had come to sell the narcotic drugs to one person, namely Shahijuddin Ahmed. That is a present petitioner, Lordship. Now, Lordship, they have carried the contraband, Lordship. They, as per his statement, yeah, that material has to be delivered to Tajuddin. Material was not delivered to him. It is recovered from the person who are in the vehicle, Lordship. Now, on the basis of the apparent, it is on the basis of the statement of this accused, this petitioner was arrested, Lordship. Now, Lordship, the point already been settled, Lordship, in Tufan Singh case, Lordship, whatever stated before the IO, it is not an admissible evidence, Lordship, as per Tufan Singh, Lordship. Now, the prime factor in this case, Lordship, has to establish, Lordship, whether the Lordship, the contraband is recovered from this present petitioner or not, Lordship. If it is not present petitioner, Lordship, the burden is not lies upon this petitioner to prove him is an innocent, Lordship. In this regard, Lordship, I have one judgment, Lordship, and I will not take much time, Lordship.
No, Mr. Upat,
My lord, on being leaded by the present accused person, the house of the present accused petitioner was searched.
No,
And
that is the wrong.
that is the accordingly complained along with DOS so and so and apprehended on Shah Nibas left for the house of Soijuddin the present at around 2 p.m. On arrival of the house of Soijuddin Ahmed at around 3:30 p.m., house search was conducted and apprehended the present accused.
however, nothing was found.
Nothing was found. But my lord, on interrogation, he admitted that he is involved in dealing of drugs with the above mentioned apprehended person from the past few months.
Now, the question is possession of 8.2 grams.
Yes. But my lord, here the quantity is 8.22 grams from the my lord three other accused persons. Now he is my lord probably a drug dealer, as he stated, my lord.
Maybe drug distributor, not dealer.
Drug distributor, dealer.
With a having valid license.
So now, what are the other evidence now? Till now, police has probably investigation is going on. If anything recovered from him or any other my lord, other materials, my lord, that will come only from the city. Will reveal from the city only.
It is not.
It is not the today for motion, my lord. Item number 3.
If it is not
The quantity is 8.2.
8.22 and this petitioner is in
Then
20.
why
that small
special
quantity.
judge rejected your
Lordship,
petition order?
My lord, that small quantity is from the apprehended accused person. From
not for
this,
this
That is the allegation.
that allegation. Maybe my lord, during on being leaded by the
Lordship, I have annexed the
that
seizure,
accused
Lordship.
person, maybe my lord, something more
Presently-
incriminating discovered, my lord, recovered from the present.
Why the
That order, Lordship, because it is rejected, Lordship, I have not annexed
They
that
will
order,
have to
Lordship.
annex that order because from that
Lordship, since is a coordinate, Lordship, since I have stated, Lordship, it was rejected, Lordship, so kindly see the seizure list, Lordship, whom it was recovered, Lordship. That's why, Lordship, I am relying on this judgment, Lordship, recent judgment reported in, Lordship, 2023 GLT, Lordship, Balwinder Singh, Binda, Lordship. Okay. Lordship has probably
on
gone
the statement will
on
not
page
help
16, Lordship.
because from that order,
Paragraph 16, Lordship. Here also, Lordship, the case, Lordship, what happened, Lordship, that the person was coming with a vehicle, Lordship, his vehicle was intercepted. When intercepted,
quantity is very
very
quantity
less,
is
Lordship.
less, my lord.
and he has been behind
But
bar.
that quantity is not from the present accused person.
That is the
And present case nothing has been
Nothing but my lord, only case diary from the case diary. Probably my lord, because he is a drug
why should
distributor.
he remain in jail?
So
It's a
maybe
valid
my lord,
violation
during
of
this
21
period,
law.
my lord, some more other incriminating materials
That
may be,
subsequently it will come.
because they are mainly dealers of the from other accused
you
persons.
have not even make the objection.
That
Well, on
Lordship, I
fourth-
have stated
on
it is
3rd or
rejected,
4th of
Lordship.
January,
It
I
is
can
rejected,
produce the
Lordship.
case diary.
Since the Lordship 20 days, Lordship, nothing has been recovered. Para 16, Lordship, when the recovery was not made from this petitioner, Lordship, the Supreme Court has acquitted the Lordship Balwinder, Lordship.
But that
That
forwarding
para,
report is of,
Lordship, is para 16, Lordship.
my lord, that forwarding report is of dated 3/12/23, and today is my lord on that my lord 20.
Single day detention is illegal, Lordship, if it is not recovered from this petitioner, Lordship. Violation of 21, Lordship, is there.
Then
Possession loss, they have to establish it is recovered from my possession loss. If recovery is silent lordship, subsequently what happened lordship, at the point of time lordship, they could not recover anything lordship. They have searched my house lordship because the forwarding report is that one. 29 is there lordship, abatement. Lordship, now the things is, the contraband was not delivered to this petitioner only because of the statement of the Shanwas lordship. He said this petitioner was arrested lordship. That cannot be entertained lordship in the 67 is bar as per lordship Tupang Singh judgment lordship. That was discussed in this case also, Lord.
only case diary will reveal, my lord, what are
Considering the
materials.
length of detention, he may be released because of the he's a drug distributor, lordship, having valid license, trade license, all are there, lordship.
No, that is relevant.
Because material was not delivered. If something lordship, I can say I'm bringing this material to for this public prosecutor. Will he be arrested, lordship? Only because of my statement, lordship. Because that is nothing recovered from him, lordship.
The present accused person also admitted that he is involved in dealing in
That
drugs
one, the
with the above mentioned
67, then 67.
Hard to keep put up. This application for 9. That's 5 to 3%. Yeah, right. That's
3/12/2020.
what last connection. Join up here. It's 5. This 3 1 X 1 SI of 5 at 5 and 5 for the judgment of the formation Naka checking during Naka checking with one vehicle bearing the in 8 and 7 E 9504 was intercepted. And during search of said vehicle, two occupants were found in the name Sahil Hussain and Johnny Chok.
3%.
Johnny Chok and Matan was done. And during search of during their search 10 numbers plastic wire containing yellow color powder suspected heroin was found from it. Total quantity of these heroin was 8.22 grams. It further testified that during interrogation, one of the apprehended charge was revealed that he had come sell narcotic drugs to the present petitioner. Both known the drug that counsel for petitioner had submitted nothing was the merely on the basis of statement made by Coek arrested
20 days.
19
Counting today of that case close to the forwarding date also will be counted.
that counsel for petitioner had relied upon Parking for that.
It is Lordship Balvinder Singh. This one is Balvinder Singh. Binda.
What is that?
Their Lordship, that's Tufan Singh reference was there along with Lordship. The recovery part is there, Lordship. If it is not recovered, the burden will not lie on the Lordship, this petitioner too.
Where is Tufan?
Tufan Singh reference is there, Lordship, in para. Para Lordship 8. Para 6, 7, 8, Lordship. 6, 7, 8, 9.
Tufan Singh for state reported in 2021 4 HCT 1 where it was observed right export that statement made by accused or the co-accused was under section 67 of 67 of DPS Act not with and conviction only of it purported statement of confession. And statement made by under section 67 not in law. The extent with counsel for submits that current forwarding for that file with investigate that where is the forwarding
Forwarding report, Lordship, will find on page
20.
20.
20.
forwarding report dated 3/12/2023 filed by court court visit of the full with for arresting and investigating the present statement point. Nothing has been covered. On the other hand, those submit verifiable statement I have considered both have serious credible content next not the quantity of probability in this case is only 8.2 grams. Petitioner has already been paid for last 20. Further, also appears it apart from material the record that the seized contraband was not recovered from possession. Considering fact, considering the above fact, as well as quantity of contraband, this court is further consideration of it. cannot if otherwise cooperate or fair competition. Side of state, 5 view of the type Ahmed Airman of labor like subject done it special judge
I mean,
with following
highly obliged, sir. Obliged, sir.
Lordship, the FIR is at page 10, Lordship, Annexure 1, NDPS case, Lordship,
what case?
NDPS. But Lordship, there, the petitioner's name is not there in the FIR, Lordship, page 14, Lordship.
Then why are you apprehending it?
Lordship, while Lordship preparing the charge sheet, my name was included along with two other accused persons, Lordship.
Charge sheet has filed.
Charge sheet filed, then NPW issued, then Lordship, we have filed a criminal petition before this court, and this court finds that the NPW were issued illegally or Lordship without issuing any summons, any warrant. So all the NPWs were satisfied, and the petitioner was directed to appear before the court people for taking regular. I approached several advocates, and now still apprehension is there that Lordship, whenever I will appear before the trial court, the petitioner will be taken. So my humble prayer before your Lordship, some protection may be given.
21 now.
Lordship may kindly
So-
see whether I am involved with this case.
For
For
that,
that only your Lordship kindly go through the FIR.
no, FIR would not reveal everything because
Lordship at least started to reveal something. There was no offense in regard to the petitioner. Lordship.
let us go. Okay, what-
May I read the FIR?
otherwise without going there, I think we have to peruse the
My lord,
For that only, Lordship, I have enclosed every document along with this AB Lordship. And my only apprehension that Lordship, I have filed 2 petitions with 2 advocates Lordship. Those were returned. The petitioner was called with partner Lordship. I am apprehending my dear Lordship may be taken into custody, and 2 persons who were already arrested in connection with they were red-handed caught Lordship. They were by the police Lordship. They
No,
were inside the jail.
as because charge sheet has been filed under section 21C.
Lordship, I am
So,
not
there
concerned
is
with the materials, Lordship. I am not concerned. The charge sheet itself says there is no, it reflects nothing about me, Lordship.
Then
Kindly see
why-
page
then
70.
what is the allegation against you in the charge?
Lordship may kindly see annexure to page 70, Lordship. Last paragraph. Serial number 10 says particular of accused person charge sheeted. Saifuddin.
In 21C, it is very difficult without going through material
Lordship, my humble
to
prayer.
arrive at the.
I am ready, Lordship. My father recently died and I am the eldest son of the family,
No,
Lordship.
Those are not the.
Lordship, I know Lordship in NDPS those may not be considered for only to
Mainly
advise
in
the
the
court.
commercial case involving commercial.
Yes.
I have to arrive at a reasonable belief that you are not guilty.
Lordship, I am ready. Your Lordship, kindly see the order which was passed by this court, Lordship. As the NVWs were issued most illegally without someone, without warrant, Lordship, I am very much present. I was doing my contract work, Lordship. That
No, that is
agreement
okay.
also I have annexed.
That the law says that.
But Lordship, under 482, no bail can be granted. So Lordship, within 482 limited power, Lordship, accordingly that was allowed, directing, setting aside all the NBW. Page 63, your Lordship, kindly. page 63. It was my fault, Lordship. I have
No,
filed
okay.
482, Lordship.
Page 63 is okay that
Lordship.
NBW was issued without issuing summons.
Lordship. So all
it
the
was
NBWs
rightly
were
quashed.
yes. Only
But
Lordship.
that would not entitle you to get bail.
Lordship. Only consider my case, Lordship. I'm ready to cooperate with the
No,
trial, your
that,
Lordship.
that relief is not available with,
But
because
Lordship,
of
here
7.
Yes. One order was there that you go and appear for regular bail, your Lordship. That was also directed. There was no mention that that should be considered in accordance with law. Only, Lordship, today is the last date, Lordship. Thereafter, NPW will be issued the trial court. So some protection, Lordship, within 10 days I will appear, Lordship. Lordship, grant me some protection, Lordship. I will appear
That
and
is
I will
not
cooperate.
with me. That relief is not available without
Lordship,
going through the material. Because for getting that relief, you have to convince the court that there are no reasonable grounds to believe
And moreover, my lord, a coordinate bench has passed in a 482, of course, my lord, 482, directing them to appear before 10 days.
as Lordship,
So
bail
that
cannot be
portion,
granted.
yes, my lord, if they are agreed by that portion, NBW, my lord, already set aside, my lord, if they are agreed by that portion, they have to appeal. My lord,
No,
otherwise, my
Lordship,
lord,
even yesterday also we tried to file one application that was not accepted, saying that the petitioner, the person to be produced. So I have reasonable apprehension, Lordship. Already 2 persons were inside the bail, Lordship.
No,
I am
your
not concerned
apprehension
with
is
them.
right.
being
Lordship.
absconding, my lord, since March
No, Lordship, I am
2022.
not
I am not on
absconding.
that.
Lordship, I am not
I am on the
absconding.
powers
The
of the
agreement
court.
I have
Yes.
annexed, Lordship. 438, your Lordship has ample power, Lordship. There are getting
438
of
is,
judgment.
but you have to show that there are reasonable grounds to believe that you are.
Lordship can go through the chart sheet. Lordship will find there is nothing in the chart sheet. Lordship. Chart sheet,
No,
your Lordship,
show me.
page 17, Lordship. Annexure 2, Lordship.
Against you.
Yes, Lordship.
Absconding, my lord, page 17.
Particular
What
of
is your
accused
name?
Lordship, absconding, Fazlu Mia, then number 2, Suleiman Uddin, then number 3, Sajiduddin, Lordship.
Page 17. Last page.
I am Sajidul Haq, but here I am shown as Sajiduddin, son of Khairuddin. The charge sheet did not disclose, Lordship, any materials against me. There is nothing, your Lordship, the charge sheet. And there are so many irregularities in the trial also, Lordship. Those we have shown in our criminal petition, the courts, after satisfaction, passed this order, Lordship. PW1 was already recorded, your Lordship. There was no splitting of the trial, your Lordship. Still, absconders were, Lordship, NPW were issued against absconders, Lordship. And in the against the Lordship, the persons who were arrested, already PW1 was taken by the trial court. There are so many irregularities, Lord. But Lordship, for that the petitioner should suffer. My humble prayer before your Lordship. Today is the last date, Lord. So from tomorrow, Lordship, again NBW will be back to the
What is your name?
Sajid Uddin, Lordship, number 3. Simply saying that absconding, Lord. On what basis it was, Lordship, there was nothing in the chart, Lord. So some protection may be granted, Lordship. I am very much willing to appear before the learned trial court. And Lordship, I have enclosed one agreement also that is dated 14/11/2022. I am very much present in the Karimganj, Lordship, doing agreement, contract work.
No, not without. Yes, Mr. Parat.
Some protection, Lordship, I will appear.
I have objection, Malad, because Malad, it amounts to violate the earlier order. Malad, earlier order this could directed in 482 to appear
No,
before
Lord, I am not
within
violating.
10 days. Malad, that second portion, Malad. Already NBW set aside and directed to appear before 10 days. And though this is not Malad, in the order that it will be considered. Obviously, Malad, any bail petition will be considered only, Malad, in accordance with law. For dear, Malad, no specific order is required, Malad. Every application petition will be considered by the learned trial court in accordance with law, Malad.
No, unless we go through the case diary,
Yes, my lord, can copy.
case diary and the material, we may not be in a position to arrive at the finding that there are reasonable ground to believe.
Lordship may grant interim protection as
No,
per.
for that also I have to arrive.
I will appear before the learned trial court. In the meantime, Lordship, if after receiving the case, there is scan copy, Lordship, if your Lordship is not satisfied, your Lordship may cancel.
No, not in a case under 21C, unless I am convinced that
Lordship,
you are
I
innocent.
have shown the Lordship that in charges there was no allegation against the absent person in regard to 21C. So, my Lordship, at least 15 days bail protection, Lordship. In the meantime, I will appear. And thereafter, your Lordship may cancel my bail. I have no.
No, for giving you interim protection, I have to arrive at that finding that you are innocent. But as charge sheet has been
Lordship,
laid,
charge sheet, there is nothing in regard to the petition. Your Lordship can record that. There was nothing in the charge sheet, Lordship. Charge sheet is before your Lordship, page 17, your Lordship.
How to overcome my lord, section 37?
No, Lordship, that part during investigation and during trial, that part done, Lordship. NPW has already set aside, and Lordship, trial is now going on. Only for this limited period, I am praying before you. At least 15 days protection may be given for.
no, 15 days you have to help yourself. I am calling for the case without going through the material.
Lordship, I will appear. Then, Lordship, after receiving.
More
Can
so
copy.
in view of the directions of the coordinate bench, where specific directions are given. Surrender. So without perusing the case diary, it is a difficult. Heard Miss R. Chaudhary, Senate Counsel for the petition.
I want the question, madam. Yes, it is true, madam, without going to law, your lordship, I will satisfaction, madam. I want the question is, madam, only short date, madam, because your lordship may fail.
I'll give this shortest days.
But even then, madam, I am not idea than 4 days.
Yes. It may be on third.
What? If, fifth, madam.
Okay. Because without perusing case diary.
No, that I understand.
Huh?
So maybe on third, madam, if I am not there.
Mr. Parashar, you also go through the charge sheet.
Nothing.
There is a defect in the charge. But there may be other material. 161 statement. On what basis charge sheet has been filed?
Only matter on the face of it, there is nothing against them in the charge sheet also.
But charge sheet has been filed.
That's true. That's true. But what they have said, absconding. Anyway.
Yeah. Heard Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Ms. R. Chaudhary, Learned Counsel for this application under section 438 of the Code of Criminal Procedure, 1970, and filed by the side of who is apprehending his arrest in connection with special NDPS case number 40/2022 pending in the court of Learned Sessions Judge Karim. Call for the scan copy of the case record of special NDPS case number 40/2020 as well as scan copy of the case diary of Patharkati PS case number 69/20 from the court of Learned Sessions Judge Karim. The registry shall take steps for requisitioning the scan copy as directed above. Let this case be listed again on 5th of April.
Only if possible, if your lordship, only part of my submission that in the charge sheet, no allegation, nothing.
Okay.
Simple, they say absconding.
Here I got for Learned Counsel, Learned Senior Counsel for petitioner has submitted that though charge sheet has been laid against the present.
No, whisper against.
However, no allegation has been made against the present petitioner, except mentioning the fact that the petitioner has been absconded. And only allegations are made against the arrested. Third,
On third.
on fifth,
Third.
okay, on third.
If that will be.
Third, that court will reopen only on third, I think.
Let it be on fifth.
Ken copy has to come and they have to prepare. Otherwise, we have no.
My lord, this petitioner, twin number, my lord, arrested on 1/12/2023, my lord. Let me kindly see the FIR page 9. My lord, allegation under section 379. In the FIR, my lord, their name is not there. It is, my lord, specifically stated that accused number 1 and 2.
You were arrested on?
My lord, lost me kindly see forwarding report. 1/12/2023, I was arrested.
What was theft? Motorcycle.
Yes, one Pulsar bicycle. Theft. Lost me kindly see forwarding, my lord. Nothing about me, my lord. In the FIR also, in the forwarding also, my lord.
What is your name?
My lord, my name is in forwarding P. Gulab Hussain and Basar Ali, my lord. 4.
Is there butter?
My lord, nothing.
Otherwise, case there will be necessary regarding the theft, some group may be involved, but here point number 5 only 1 and 2 there may be the prime, my lord.
Yes, my lord.
But without involving of these two petitioners, certainly
Already 22 days, my lord.
but something is here, but in the city.
As per my lord, the articles has been recovered already, my lord. Ground number 2, my lord.
No, why your prayer was rejected by?
This, my lord, this order simply speak that, my lord, something incriminating material against all, my lord. So I annex this order. Let's see, we'll find page 20, my lord. Annex of 4.
Some materials are there.
My lord, in my petition I stated, my lord, I am the.
But in the ejection order, the SDGM says that.
Yes, on perusal of the city.
So perusal of.
Yes, simply here, my lord, nothing, only incriminating material.
Mr.
I pray for started.
Counsel for the petition also heard Mr. K. Parasar petitioner call for the fifth.
Subject matter is primary plastic. Petitioner number 1 is the husband and number 2 is the other of the.
Already submitted.
Victim has a 10 minor case, and I have placed the
Interim. There are interim or Shastir already submitted, madam.
You are on interim.
no interim.
Then you appear before the trial.
Maybe
Heard
right.
Mr. A.H. Ahmed. A.H. Ahmed. Senate counsel for the petitioner, also Mr. K. Parasar, petitioner, who submits that though the case diary was called for in connection with the case, however, in the meanwhile, charge sheet has been made bearing charge sheet number
57/23 dated 31/5/23.
in view of submission of the charge sheet, the anticipatory bail application is disposed of with an observation that the petitioner may approach learned trial court and may pray for appropriate relief before the trial.
Put at me.
CD was called for.
CD available.
Yes,
CD was called for.
it is there.
CD available. Apparently.
LH section 341, 354, 509, 506, 363, 511. All sections are available. Only 354 is not available. But 350 is not applicable. Because FRS itself. That's good.
Where is the affair?
Page number 10. May I read, my lord?
Yes.
May I read, my lord?
Yes, yes.
With due respect, it is informed you that today, 23/10/2022, while my daughter returning home along with her sister from watching puja, some unknown youth unlawfully restrained her daughters and also made obscene gesture to them and attempt to kidnap them. Thereafter, the girls informed, my lord, may please note this line. Thereafter, the girls informed their parents about the matter over telephone, and immediately we parents were reached the place and saw that about 15 young boys with weapon in their hand, and they threatened us with dire consequences. They wanted to kidnap her, and they are waiting for their parents. Minimum half an hour, my lord. They have not kidnapped, and they have not. They were safe, my lord. Girls were safe. So we able to name some yacht and hand it over to you. Among them who were in police custody. Names are, my lord. As such, I paid before your text. So appropriate.
Yes, Mr. Parat.
My lord, yes, it is available, my lord. Here, my lord, three girl, my lord, there were coming, my lord, and nearby their house, my lord. At the first time, my lord, there is 164 statement of my lord, three girl, my lord. At that time, my lord, 3-4 boy, my lord, stopped them and asked some gesture and all this, my lord. At that moment, they call one of their brother. He came, and at that moment, some couple between that boy, my lord. And in the meantime, they have called other 15 person, my lord. Other person gathered, my lord. Now these 3 person are total 3, my lord. These are not the main, my lord. At the first time, who subsequently they have come, my lord. And but specific name are not there, my lord. Girls have paid, my lord. मतलब धक्का मारे and all this, but not
Whether name of the
name no, none of the girl मतलब 164 name taken name. One person was arrested, मतलब subsequently he was released on bail. He took the name of 2-3 others, but not this.
Heard Miss M. Das, Learned Council.
And मतलब one thing is that मतलब 41 and notice already issued to this person. मतलब from the IO note, मतलब IO note dated 6/11. 41 and notice issued to this person. Maybe they are in the group, so to ask something. The apprehension is not there, मतलब.
Why are you apprehending that?
Is often visited.
Heard Miss M. Das, Learned Council. Also heard Mr. K.K. Corruption and the petition of people. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioner, namely Amirul Ali, Wahid Ali, and Arshad Ali, who are apprehending their arrest in connection with Sadia PS case 181/2023 under section 341, 354, 509, 506, 511, and 34 of the the gist of accusation in this case that 23/10/2023, one Anu Das Deori lodged an FIR before the officer in charge of Sadia police station, interior, alleging that when the daughter of the first informant was returning back to her home, to her house, along with her sister, after watching puja, some unknown youth unlawfully restrained them and made obscene gestures and attempted to kidnap them. Thereafter, the said girls informed their parents telephonically and parent and on reaching that spot, the parents saw 15 boys with weapons in their hands who also threatened the first informant and first informant. It is also alleged in the FIR that some of the youth, some of the boys who were involved in the offense were apprehended by them and handed over to police. Learned counsel for the petitioner submits that petitioner is not involved. That learned counsel for the petitioner submits that the petitioners are not involved in any manner in the offense alleged in the FIR and you are also not named in the FIR. You are named.
FIR मतलब तेरा name है Amirul Wahid and Arshad or मतलब one Ashraf his name.
They are not named. Learned counsel for apart from section 354 IPC, all other offenses are available offenses. He also submits that the petitioners are ready to cooperate. On the other hand, learned petitioner public prosecutor has produced the case diary of the no before that learned counsel for the petitioner has submitted the police is searching for the present for which they are apprehending that they will be apprehending. On the other hand, an additional public prosecutor has produced the case diary of Sadia PS case number 181/23 and has submitted that the police has recorded the statement of the victim girl
164 also.
And their statement under section 1 have also been recorded. And in their statement, they have not specifically indicated that it is further submitted that one of the their statement has also not named
It took the name of other two malad, but no.
Sabir Ali also in on bail.
statement made considering submit made that what that is police has
41 A.
submit made the council. Now I have considered submit and have read it for big case diary of the appeal. Though the police has though the investigating officer has issued notice under the application. However, still they are searching for the present petitioner which has created genuine apprehension mind of and considering the fact that neither the victim girl nor the arrested quick have named the present petition of this court is of that custodial detention of may not be necessary for fair completion of the appeals. One, that in view of the above named petitioners are hereby directed to appear before the investigating officer of the appeals case number 185 within a period of 10 days from the date of this order and to cooperate with the investigation if they do so within the stipulated period of time, in the event of their arrest in connection with the appeals case number 185, the above named petitioner shall be allowed to go on bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of the arresting authority with following with above observation this bail and this bail
Keep your
This petition is seeking quashing of a complaint case by respondent number 1, who's the inspector of legal metrology. Lordship may already be aware, the Legal Metrology Act pertains to weights and measurements. And what weights and measurements must appear in a packaged good. So the complaint is that the petitioner, who's a public limited company, Hindustan Lever, is engaged in what they call.
You are arguing for final disposal.
No, Lordship, that's actually the merit. Why I'm here today is because of Supreme Court judgment in Asian resurfacing case, which basically holds that operation of stay comes to an end at the end of 6 months. Lordship, we got the first stay order in March 22, extended in August 22. So today, and respondents have not filed any affidavit. So prayer today is just for extension of the stay, and Lordship will fix the matter for hearing, subject to pleading.
PP Assam is formal party, my lord. A opposite party number.
Where is that order of which order?
Supreme Court order, Lordship, is 2018. Lordship, make this magistrate order, which is why we are here. Okay. Married. In the petition, which is going to file by learned on behalf of accused person, stating that in the instance case against which a criminal petition number so-and-so was preferred before the Honorable Guwahati High Court is still pending, and the same has not been listed since August 2022. And accordingly pray to stay the further proceedings of the instant case. Now, the record shows that no fresh order has been provided by the accused petitioner as to whether the same has been further extended. Considering the same, the accused petitioner is directed to ensure that up-to-date order showing further extension of stay in the instant proceeding is placed before this court, failing which the case will proceed in normal course in view of the judgment and direction of so-and-so in Asian Resurfacing of Road Agency Private Limited and others versus CPI 2018-16 SCC.
Otherwise, whether this case is ready for.
Lordship, pleadings they have not filed.
Okay, you have to file your affidavit.
Yeah. I will have to get the instruction because first respondent number 1 is my lord, inspector of legal metrology.
Lordship, is one more notification that I want to bring to your notice. They will have to seek instructions. This is notification pursuant to a cabinet decision of 21st October 2022. Lordship may see the operative part, the next page. Lordship, second paragraph. Government of Assam, today notification dated so and so has constituted, Lordship has it?
Yes.
Has constituted a committee to be headed by Principal Secretary to the Government of Assam to look into matters and try and bring out a policy for disposal of pending petty cases. After due deliberation, the said committee in its meeting dated 14 July 22 has resolved to go for withdrawal of minor petty cases and decided that the basic criteria for identification of cases providing punishment up to 3 years stroke fine, excluding certain categories of cases falling within this criteria. Accordingly, the said committee decided to go for withdrawal of cases where punishment is up to 3 years or fine or both under IPC or any other special acts except the following categories. We are not in the excluded list category, and our fine is 20,000 rupees. It's a fine of.
And there is no imprisonment.
If it's a recurring offense, then it's 1 year. But
Okay.
typically, it's 20,000
So,
monetary penalty.
Your submission is that your case falls within the
Yes.
policy decision
Yes,
of
they should take instructions on whether they
whether
will.
to withdraw.
Yeah, yeah.
For that, there is a specific procedure prescribed how to withdraw those petty cases.
No, no.
No, that
Their
is the thing.
submission is whether government shall have to take a decision whether to apply that policy to the cases
Yes.
of the petition pending before the trial.
Okay.
So that will have to be answered by government advocate Assam, who probably need to be appear on behalf of respondent number 1.
No, PP can also make the
If he is not made a party in this case.
Number 2.
who is the respondent number 1?
Respondent number 1 is Inspector of Legal Metrology and
Who is representing?
No, Lordship, the last order of March 22, we were allowed to impede respondent number 2, and PP has appeared, Mr. B.
So,
KK Parakar, additional PP.
no. My query was whether the case is ready for hearing. Today you are not ready for hearing.
No. Pleading
They
also
matter
not,
is
they not
discussed-
file any affidavit.
Sometimes they may not file.
Yes, sir.
So will you file any objection or
Then my lord,
no? How it means
then my lord, let the matter may come
Goswami.
up for final
What
hearing,
is-
my lord, on the
heard Ms. G. Goswami, learned counsel for the petition. Also heard Mr. K. Mr. P. Thakur, learned additional public prosecutor, who submits that he is not ready for hearing. Hence, some time may be granted to him for preparing the case. The prayer is allowed. On the other hand, learned counsel for the petitioner has submitted that the by an order dated when the stay was issued
Lordship, first 10/3/22.
by an order dated 10/3/2022
Extended by 16/8/20.
passed by this court. The CR case number 280/2020 pending before the Court of London Chief Judicial Magistrate, Kamrup Metro, was stayed until further order. However, learned counsel for the petitioner has submitted that the learned trial court, by its order dated
10.
16/10/2023, 23, by referring to the observation of the Supreme Court of India made in Asian Resurfacing of Road Agency Private Limited and another versus Central Bureau of Investigation, reported in 2018-16 SCC 299, wherein it was observed that unless further extension is provided in a stay matter in a case granted where stay has been granted, the state stage would automatically become vacated after lapse of a period of 6 months. Learned counsel for the petitioner has therefore praised for extending the stay which was granted in this case by order dated
10/3/22.
10/3/22 till for another for until further order. It will
6
remain
months, we'll hopefully
till until further order. Considering the facts and circumstances and considering the fact that the additional public prosecutor is not ready today and time has been granted to him, and it is unlikely that the case could not be heard today for final disposal. The stay of complaint case, that is CR case number 280/2020, which was granted by this court on 10/3/2022, is further extended until further order. Let this matter be listed after court. The second, there are two criminal.
One is by the petitioner, first is by the independent director, and the second is by the petitioner,
Same
the company, same complaint.
Same order.
Yes. Common order.
Oh, there is a common order.
Yes, the common order. Linked matter.
Okay, common. So after court.
Obliged.
May I please your lordship? My lord, this appeal has been filed against the judgment and order passed by learned ladies in Interim, my lord, in which case accused applicant was convicted under section 354 and 448 only, my lord. My lord, only 2 years.
Interlocutory. Third, Miss.
My lord, in this regard, my lord, I have also filed a higher application, my lord, to allow his my lord to remain in previous bail, my lord.
Before the learned counsel for the appellant. This appeal under section 374 of Code of Procedure has been preferred by the appellant, Sri Dhaniram Das, impugning the judgment and order dated 27/10/2023, passed by learned additional sessions judge within bracket FTC 1 Margarita, Tinsukia, in session case number 5 within bracket capital M/2016, whereby the how many appellants are there? Whereby the present appellant was convicted under section 448 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 6 months. The petitioner was also convicted under section 354 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 2 years and to pay a fine of 5,000, and in default of payment of fine to undergo simple imprisonment for 3 months more. Issue notice to the respondent. Since issue notice to the respondent, since learned additional public prosecutor has appeared for respondent number 1, no formal notice made to respondent number 1. As regards to respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number by registered post with any returnable after court. This appeal is admitted for hearing. Let the case record of Sessions case number 5 within bracket M/2016 be called for from the Court of London. Additional session judge FT Margaret.
My lord, my full commitment is for kindly remain with bail. Previous bail.
In the interlocutory,
My lord.
in the interlocutory, you have filed an IO.
Yes.
There I
Yes,
will
my lord.
Miss P.B. Bordoloi. Also heard Mr. P. Borthakur done additional purpose. This application, this interlocutory application under section 389 within bracket 2 of the Code of Criminal Procedure has been filed by the applicant Dhani Ram Das, praying for suspension of execution of the sentence imposed on the applicant by the judgment and order dated 27/10/2023 passed by learned additional session judge within bracket FTC 1 Margarita Tinsukia in session case number 5 within bracket M/2016. The said judgment and order has been impugned by the present applicant by preferring a connected criminal appeal which has been registered as criminal appeal number 475/2023. What is your ground?
My lord, he is newly married, his parents is separated and my lord, both the parents.
Now on merit.
Married, my lord, you but this is has taken only 2 years imprisonment, my lord. All along he was on bail during the trial, my lord.
Learned counsel for the petitioner has submitted that petitioner has been sentenced under section 354 of the Indian Penal Code for only 2 years and under section 448 of the Indian Penal Code for 6 months, and he has good ground for preferring the appeal and considering the limited duration of the limited sentence imposed on the applicant. If in the in if in the if the
Any condition
if during the pendency of the connected criminal appeal, the suspension of sentence imposed on the appellant is no, if the sentence imposed on the appellant is not suspended, then in the event of ultimately getting an order of acquittal in the appeal, he would be prejudiced if prejudiced if the sentence is not suspended during the pendency of the connected. And learned additional of learned additional public prosecutor also considering the limited duration of the sentence imposed on, considering the short duration of the sentence imposed on the appellant does not opposes the grant of bail, that does not opposes the suspension of sentence of the suspension of the sentence during the pendency of the connected criminal appeal. Hence, during the pendency of the criminal appeal number 475/2023, the sentence imposed by the impugned judgment is hereby suspended. Shall remain suspended during the pendency of connected and the petitioner and the applicant is allowed to remain on previous bail granted by. You are on previous bail.
Previous orang dua previous
But you are on previous bail or not now?
Yes, my lord.
Previous bail granted by the judge. With this observation, this interlocutory application.
Highly applied.
There is some defect in giving dictation. I will make it correct.
Yeah. All right, my lord.
May. The appeal order is in page number 92.
Why it has come to at order column?
No, especially we had submitted our the petitioner submitted a written statement, but Sam was rejected on the ground that page number 93. From the record, it appears that height order 29/2020 submission of written statement was allowed subject to payment of cost rupees 5,000. As cost is not deposited and no prayer has been made for time, it amounts to refusal to pay the cost amount. Under this circumstance, the written statement submitted by the opposite party could not
No,
be
when the
accepted.
notice has been served.
Yes,
You are for this.
Lordship, I am appearing on behalf of respondent number 2.
Yes, make it.
Yes, Lordship. The fact is that, Lordship, on 29/2023, Lordship, the date was fixed for filing written statement by the petitioner, Lordship. On that day, Lordship, 29/2023, 20 September.
It was fixed for filing
Written statement.
by you.
Yes, by the petitioner.
Okay.
But the petitioner, instead of filing the written statement, he filed a petition, Lordship, to close the case of the petitioner, filed under section 125 CRPC, claiming maintenance from the petitioner, Lordship. But yes, Lordship. Thereafter, the ground shown without filing a dubious, Lordship, stating that for closing of the maintenance case filed by the respondent number 2 on the ground that the petitioner has filed one case which is pending before the learned family court below, Lordship, case number 327/2020, Lordship, challenging the marriage between the petitioner and the respondent number 2, Lordship. And other ground that, Your Honor, during the pendency of the case, Your Lordship, the respondent number 2 entered amicably settled the matter with the petitioner, and resultantly they have executed a memorandum of understanding dated 7/7/2021. The page number, Lordship, 58, Lordship. Memorandum of understanding. On this page number 58, Lordship. This is the memorandum of understanding.
No. I want to understand why it has come at order call. You are arguing for finalist.
No, Lordship.
Then
Lordship, we will file objection on the next.
let them file up.
Before that, can you consider the interim relief, Lordship?
because on 12th of January, the next date is fixed for filing evidence. Lordship, the case is processed without acceptance of the written statement of the petitioner. If that is so, Lordship, then the petitioner will the case ultimately go against the petitioner. Lordship.
This 2923 order is, what is the 2923 order?
Lordship.
For filing written statement.
Yes, Lordship.
Then 5/10/2023 order.
65. Lordship, page number 65.
What it said?
Lordship, last para, page 66. On 13/6/2023, 1/7/2023, 9/8/2023, and today, that day, Lordship.
How much time will you take for filing?
Lordship, 15 days.
Then let the proceeding be kept in abeyance till 15 days.
On 12th of January, the next date is fixed for PW.
Third, Mr. What is your name?
A. Rahman.
A. Rahman, the counsel for. Also heard Miss. What is your name?
M. Das.
M. Das, the counsel appearing from respondent number 2, who prays for allowing some time for filing objection against the petition filed by present petition. A prayer is allowed. On this, the learned counsel for submit as the case before the trial court as the case number FC within bracket criminal case number 347/20 is fixed before the learned trial court on
12th January.
12th January
24.
12th January 2024. Unless the proceeding of the state case is kept in abeyance, before decision is made, before deciding this instant criminal review petition, he would be highly prejudiced. Therefore, learned counsel for the petition, respondent number 2 also does not oppose the grant of interim prayer for till the next day. In view of above, the proceeding of FC criminal case number 347/2020 hereby kept in abeyance until further order. The petition, the respondent number 2 shall file the evidence on the affidavit in opposition before the next day. Let this matter be listed again after 3 weeks or 6 days.
6 days.
12 or after. Okay, 9th of
Hello.
Lordship, I filed NDPS Lordship for modification of order dated 21/11/2023. Lordship, kindly peruse the pair number 4 of file. Lordship, in this case, while the Honorable Court passed the order on 21/11/2023, the inadvertently quoted the order dated 6/11/2023 passed in DP case number 194/2022 instead of impugn order dated 6/11/23 passed in DP case number 183 of 2020.
Which para?
Lordship, I annexed the order. Lordship.
No, where have you been?
Yes, Lordship. Lordship, para number 4.
Para number 4.
Yes. Lordship, I challenge the impugn order dated 6/11/23 passed in DP case number 183 of 2020. Lordship, inadvertently, the order passed in
Which
DP.
paragraph there is an error?
Yes. Lordship, second para of the order, Lordship. 21/11/2023. Lordship, 6/11/2023. Today was fixed for hearing on petition the 3736 interim relief of AL by the respondent. Actually, Lordship, I am challenging a order. The Lordship order dated 6/11/23 passed in DP case number 183. Lordship, the annexure 14 of the main petition.
No, no. You first point me out where is the mistake and what correction that was. Where
Yes, Lordship, second para of the interim order, Lordship.
second para?
Yes, Lordship. Lordship, page number 7.
Yes, page number 7. Where the mistake is there?
Yes, Lordship, while at the course of passing the order, Lordship, at the DP case number 183 of 2022. But Lordship quoted the order the passed in the DP case number 194 of 2022.
So
Lordship,
instead of DV case number 183/22, what?
yes, Lordship, but Lordship, when the order quoted, Lordship, the DP, the case number 194 of 2022 is quoted. Lordship, kindly fails
So,
to
correct number is 183/20.
Yes. But Lordship, while passing this order, Lordship, Lordship quoted the whole order passing the 6/11/23 passing the DP case number 193, Lordship. I mean, instead of Lordship, the impugn order 6/11/23 passing DP case number 180 of 2020.
So the wrong order has been quoted.
Yes, Lord. So, Lordship, actually, it should be quoted, Lordship, annex of 14, Lordship. I mean, criminal petition. Page number 161. This is the impugn order.
Page number
161. But Lordship, while passing the order, annexer 4 is the quoted. Okay.
No, Mr. Counsel. Instead of 611, what should come here? Page number 161 should come here.
Yes, Lordship. Lordship, Honorable Court, quoted Lordship, the annexer 4, Lordship. Page number, Lordship, 93. Order is 6/11/20.
Understood. Now, what should come here?
Lordship, it should come here, Lordship, order dated 6/11/23 passed in DP case number 183 of 2020.
That is annexure 4.
No, Lordship. Annexer, Lordship, 14.
Page number?
Page number 161.
This order has been wrongly quoted.
Yes.
Which order has been quoted wrongly? By instead
Lordship,
of
annexer 4, page number 96. Lordship. What the order was passed on same day.
Heard Mr.
Actually,
S. Theory that appeal for petition authored the board of petition for this interlocutory application as filed by the petitioner praying for correction of order dated 21/11/2003 passed by this court criminal petition for 1/5 that is submitted by the of 21/11/2023 instead of quoting order dated 6/11/2023 passed in DB case number 183 order passed in case 190 it is submitted that name correct perusal of the that in fact the quoted order has not of the order passed on 6/11/2023 DB case number 183 but of order dated 190 it appears to be due inadvertent mistake committed while quoting the said name needs therefore therefore said order therefore the order dated 21/11/2023 passed by this court in criminal petition number 1255/2023 following order date as passed on 6/11 DB case number 180 quoted court of quoted order dated 6/11 180 certificate order dated 21/11/2023 1 to 5 and based on what has been from with the top of the is you go through the order. I will go through the earlier wrong this thought has been in continuation shall be read in continuation the order dated 21/11 passed in criminal 1255
May it please your lordship. Lordship, this is an interlocutory application filed in a bail petition disposed of, my lord, allowing the applicants before your lordship on bail. I seek modification of one condition, that is my submission of my passport, my lord. And the prime accused, my lord, his passport has already been released also. Okay. First of all, my lord, I would like to take your lordship to the FIR, my lord, page number 12, my lord. Page number 12, there is the FIR of the instant case. My lord. My lord, the condition lordship would find, page number 15 is my bail order, my lord. It is the bail order dated 9/9/2021, my lord. 9/9, more than 2 years back, my lord. Here, in this bail order, granting bail to the applicants who are husband and wife, my lord, in page number 23, my lord, condition B, that shall deposit his passport, etc., if any, in the court of the learned jurisdiction of special judgment. So, on 9/9/21, when I was granted bail, on submitting my bail bond, I had submitted my passport, my lord. And my lord, there is another condition also, because even if my passport is returned to me for renewal, or if I want to go abroad as well, my lord, there is condition A, my lord, which is there. Even if my passport is with me, I have to take permission from the trial court. The trial court will decide whether my going abroad is justified or not, whether I can apply for visa or not. So I'm praying for my passport, my lord, because the next year renewal is also required. And other documents I have annexed because my sister recently gave birth to, my lord, a baby, and they are residents and citizens of the United States, my lord. And the visa procuring process takes a lot of months, for which the passport needs to be deposited. And my lord, on top of that, my lord, the primary accused of the instant case, my lord, in whose house the alleged incident party took place, because then, my lord, FIR named prime accused, his passport has already been released by this honorable court, my lord. Page number 33, that order is there, my lord. There was no objection as such. And because, my lord, now only the case is in copy stage for more than a year, my lord. Charge needs to be framed, FSL has not come. We're looking at 3-5 years, my lord, for the at least 30 trial. So page number 34, my lord, last paragraph. Accordingly, the condition number B of the order is 7/10/21, that is depositing of the passport in bail application number is hereby modified. In the learned court of additional session judge number 5, Kamrup Petro is directed to release the passport of the petitioner by retaining a legitimate copy. Well, anyway, I have to seek permission from the court while going abroad, but for renewal and also. DK Boito. But B, my lord, condition number B of paragraph number 17. Yes, yes.
As
My lord, petitioner number 2, my lord, applicant number 2, her sister and sister's complete entire family, they are based in the United States. Applicant number 2, sister, my lord. Paragraph number 6, my lord, at page number 6. Passport.
Past I therefore text both past the passport for the entire while submitting it of
He shall not violate the other conditions of the bail and ensuring his presence during trial.
does not therefore release of the passport. However, it not violate the other which were both of them you submit and it with this and for purpose for the other party of the 7 must be by right with their present cooperation and if therefore got according to the of the order it 99 are there also bail application
Bail application number, my lord, 2035
hereby modified in the learned trial court is hereby directed to the of the petitioner by retaining the people can of the
Highly object.
Lordship, in this case, notice already been served to the respondent for two, and already been served, but it's not appeared. Its name is already reflected in the first report. Lordship,
Postco it, my lord.
we have challenged this order, Lordship. However, Lordship convicted the appellant.
No, whether the cause title has been amended.
Yes, yes. Appellant has been convicted, Lordship, 3 years under section 12 of POCSO Act, and and 3 years also under section 354D, and 2 years under section 5065.
That to run
Consecutively, that is the problem. Because Lordship, this is the
that is
violation
the
of
problem for you.
yes, Lord.
Yes, sir.
But,
Your Lord,
but
this
perhaps
is the violation of section 42 of the POCSO Act. Not 42 may be said, Lord. May I read, Lord? 40. It's clear. Lord. When an act or omission constitutes an offense punishable under this act, or also under section 166, 354A, 354B, 354C, 354D, 370, and so on sections of Indian Penal Code, then notwithstanding anything contained in any law for the time being in force, the offender found guilty of such offense shall be liable to punishment under this act or under the Indian Penal Code as provides for punishment which is greater in degree. We are here in this case, Lord, punishment prescribed in 354D and 12 is same, Lord. So, learned court will choose one section, Lord, which is greater in degree, Lord. But here is, in both the sections he has been convicted, Lordship, that too, Lordship, consecutively. And in this regard, we have brought an judgment also, Lordship, here. Judgment also in regard to the fraud. So at this stage, Lordship, we have filed a suspension or sentence, Lordship, that may be considered, Lordship, and I may be allowed on bail.
the notices are served.
Yes, Lordship, their name is all reflected in the FIR, A. Thakuria 1.
Your appearance is recorded.
Where is the office note there?
Possibly reflected. That's one of the reflected.
No, you have gone through the record.
In respect of the respondent number 2, we have not done the record, but it is reflected in Cosby. 1 A. Thakuria is appeared on behalf of the
Sometime
Palatama is there, my colleague.
No, I'm not getting.
He said, "Wakalat, how